Can someone please tell me if I'm logged into Wilson County?
Yes.
Thank you, sir.
What is your name?
Glory Pinchorn?
Thank you.
Okay.
All right, ladies and gentlemen, I have about 9 o'clock. We'll call the criminal dockets, then the civil docket. Ask for announcements from the attorneys. Anyone who's present who doesn't have an attorney or your attorney doesn't answer, please make sure I know that you're here. Other than that, please keep your electronic device muted. State versus Diedra Silva.
He's in our waiting room, Your Honor.
And Your Honor, that is going to be a plea. I believe all the paperwork has been completed.
Excellent. Albert Aguirre.
I believe he may be in custody, Your Honor.
He is in custody, Your Honor. That's my case. We're gonna need to keep conferring on that.
Griselda Vasquez.
Good morning, Judge. She's present with counsel and we will be conferring. Thank you.
Thank you. John Wesley Albright. All right, we'll check on Mr. Laura. No show. Alma Suarez. Alma Suarez. And do we have the interpreter here today?
Judge, I verified with Ms. Carrillo and she does not need an interpreter today. It was going to be a reset.
Okay. Felipe Rodriguez.
Oops, there, go ahead.
I'm here, sir.
Okay, Ms. Tapia, I see you check in. All right, I'll mark you present,
Here
Mr.
you go.
Suarez.
I'm trying to get set up.
Okay. All right, and Mr. Moreno, I saw you logged on.
Yes, Your Honor.
All right. Ms. Silva's in the probation office, I believe.
Yes, she should be there. That's what we discussed yesterday.
All right, James Sellers, is he in custody?
Yes, Your Honor, and that paperwork is done, and that is going to be a plea as well.
Stephen Salinas?
That is correct.
Stephen Salinas? No show. Jose Rios?
Your Honor, that is set for a sentencing today. State is ready to proceed whenever the court is ready.
And defense is ready to get as well, Your Honor. I believe Mr. Rios should be at the probation office as well.
He is in the courtroom lobby, Your Honor.
Thank you. Gilbert Salinas?
Good morning, Your Honor. Nathan Slamane. I'm present for Mr. Salinas. He is not on. I spoke with him this morning. He does not have technology to join us. I tried to give him the phone number information to dial in. He was saying he didn't have a pen. So that's kind of where that is right now.
All right, well, he already has a date for 3/18. Oh, no, I'm sorry. Not till 6/17. No, we need to hear something from him before 6/17. If he's not able to sign on electronically, then he can appear at the probation office or in the district courtroom.
Okay, Judge.
Judge, those are previous dates, just to show that that was his last court date. This is his first appearance since everything shut down. Those are not
Those are
future
from
dates.
last year then. All right.
Yes.
Judge, would it be all right to just go ahead and bump this to the 5-3 pretrial and hopefully he can get back online by then?
No, we need something this month.
Okay, Judge.
Joe Luke, and I'll mark him no show for the time being. No, Joe Luke Sanchez?
Is in custody, Your Honor.
Nathan Wheelis?
Present.
I'm present for him, Your Honor, and we'll reset it to the 5-3 date. I'll put that in chat.
Thank you. Ricardo Gonzalez, that's a commitment, I believe.
Yes, Your Honor.
I'm present for him, Judge. I've been in conference with Miss Whitney. I've been emailing Dr. John Fabian, and we're trying to get him on because Mr. Gonzalez has 2 cases in Bexar County as well. We're trying to get him as an expert witness on the case.
Okay, I'll mark you conferring.
Thank you, Judge.
Joe Luke Sanchez, custody. Christina Sapp. Christina Sapp.
Judge, I'm present on that. I don't know if that I've had any contact with her, so if you'll just recall that, please.
I'll recall, no show. Bethany Hinojosa.
Your Honor, that was reset yesterday. Her son passed away.
Okay, all right. Just put new dates. Matthew Rose.
Present, Your Honor, and
Present,
he's
Your Honor.
present as well, and we will be asking to remain on the 5-3 setting.
Thank you. Rogelio Tellez.
Again, Judge, I haven't had any contact with him, and if you can recall.
All right, mark him no show. Blaine Torre.
Judge, I'm present on that. That was Mr. Torres executed the PTD paperwork and he's gone to probation already.
All right, so I'll just put pretrial diversion. Is that all you have?
That's all I've got, Judge.
All right, you're excused. Have a good day.
Thank you, Your Honor.
Daniel Gibson.
Judge, I have information from his family that he is in custody, in federal custody in DeWitt County. I haven't had a chance to confirm that yet, but that's my understanding.
Physically in DeWitt County or charges out of DeWitt County?
I believe physically in DeWitt County.
Okay. So they're just throwing him in the jail, you mean, or?
I suppose. I haven't been able to confirm anything.
All right, let's check on that. John Joslin?
I'm present for Mr. Joslin, Your Honor, and I don't see him on, but Mr. Joslin, if you're here, please announce. We'll go ahead and get him on the phone, Judge. I apologize.
No show. Norval Lynn, I saw Mr. Lynn check in.
Yes, sir, and I'm present for Mr. Lynn. We'll be asking to remain on the docket.
Joe Luke Sanchez in custody. David Greenwood.
He is present, Your Honor, and I'm here for Mr. Greenwood. We'll be conferring.
All right. Is that 361 number David Greenwood?
No, Judge, I saw his name spelled out somewhere.
All right, who has a area code 361 telephone that ends in the digits 937?
That's me, Your Honor, John Jocelyn.
Okay, I will mark you present.
Thank you, Judge.
Thank you, Judge.
Okay. Joe Luke Sanchez again in custody. Luke Clark.
Judge, I'm present for Mr. Clark. He's at our office in Floresville trying to log in, and I don't see that he's logged in yet, so let me check on that.
Okay, we'll recall.
Oh, Judge, there he is. I'm sorry. He's present. Mr. Clark, if you'll unmute yourself and announce to the court that you're here.
Okay, what name is on there? Is it Clark?
It shows Luke Clark, yes, sir.
There he is. Okay, thank you.
Thank you, Judge.
Norval Lynn is here. David Marroquin. David Marroquin, Mr. Nitz.
I'm here for him. I don't see him on. Let me get off again and see if he's available.
All right, I mark him no show recall. Tristan McCloskey.
Judge Edward Adams present for Tristan McCloskey. He's here. Tristan, would you unmute yourself and announce to the court?
I'm here, Your Honor.
Judge, we're gonna reset for the May 3rd reset date.
Okay,
Once I post that, may we be excused?
yes, sir.
Thank you.
Christopher Perez, motion for new trial. He's in custody, I assume.
He is, Your Honor.
Okay. Is Mr. Henriksen here? Not yet, okay. Land Rutledge.
He is in custody, Your Honor.
You heard from Ms. De La Garza?
I have not, Your Honor.
She was on a while ago, Your Honor. Let me see if I see her.
I'm present, Your Honor. I'm displaced. I still have no water. So
Oh, goodness.
I know. Things have been crazy. I have not spoken to Miss Whitney, but I am trying to coordinate 3 cases again, and I'd like a reset. I don't know when the next available date is. I've been really out of pocket.
Okay, well, if you'll look at in your chat, the coordinator's office has posted all the dates in chat. And for the time being, until we get back into having jury trials or I change my mind, as long as the attorneys for both sides have agreed on a date, just post it to me in chat and you're free to go after that. Just post it in the cause number, name, and date format, because there's no sense holding people's feet to the fire to.
Right. Now, how do I speak to Miss Whitney about an agreement for a date?
Okay, you can talk to her in chat there at the bottom or get a breakout room after the call of the docket. Dimitri Ortiz.
Your Honor, that's set for a plea today. All the paperwork is completed and we are ready to plead.
And he is in our office, Your Honor.
Okay, and Mr. Dominguez, I do not have your plea packet. Are you there,
He
Mr.?
sent it last week to you,
Okay, let me go back and look.
last Wednesday when we had court.
Last Wednesday, I never received it when we had court. That day it did not come through. I don't believe. I'll go back and double check that though.
Yes, I have no documents in my Wilson County folder with the name Dimitri. Christopher Houghton.
Your Honor, that is also set for a plea today. Paperwork has been completed.
And Your Honor, on both my clients, I sent them the wrong address for adult probation to go show up this morning. So Mr. Houghton was driving around downtown Wilson.
He is here
trying
in
to
our
find
office.
it. Oh, good. He's there now.
All right. Charles Roland Jones. Mr. Lambert.
And Your Honor, I do have that packet from Mr. Dominguez. Sorry, Mr. Dominguez, I will get that sent over to the judge.
Okay. Okay.
Charles Jones is in El Paso, Your Honor. I don't believe he is currently here.
In custody in El Paso or just in El Paso?
From what I heard, I think he's being held in El Paso and to be released back here. That's what his wife told me on the phone.
Okay, so in custody, not like being held by debt collectors.
No, he's in custody in El Paso.
That is the information I received from the jail, Your Honor. They were scheduled to come and pick him up before we had given him this court date. So they took him and we'll send him back.
He is here?
No. They will send him back. He is in El Paso County.
Cameron Mathewson.
Your Honor, Sylvia Gonzalez is here for Mr. Matheson. We need to confirm, trying to get him on the Zoom.
Mark him no show for the time being. Gabriela Mendoza.
Your Honor, that is set for a plea. Paperwork has been completed.
And she is in probation, Your Honor.
Gloria Pinshorn. Ms. Pinshorn's present, I know.
Yes, Your Honor, and that is reset for Monday, Your Honor, the 8th, by agreement.
That is correct.
All right, 3-8. Land Rutledge again. Recall.
He's in custody, Your Honor, not a recall.
Oh, okay. Dennis Fraga.
Council's present, Your Honor. He should be signed on. I gave him the information yesterday.
Mr. Fraga, are you signed on? All right, I will mark him no show for the time being.
I'll look for him. Thank you, Your Honor.
And Sergio Diaz.
Your Honor, that is set for a plea. Paperwork has been completed.
And he is present in our office, Your Honor.
And we're ready, Your Honor.
Nancy Davis.
Present, Your Honor, and she is present as well, and we will be.
Thank you, Your Honor.
Thank you, ma'am. Augustine Ramirez.
He is in custody.
James
Adrian
Sellers.
is running late today, sir.
Yes, that's the other case. Yeah, that's going to be a plea.
Christopher Houghton again.
Again, Your Honor, he should be in probation for plea.
Right. Sean Spalding.
That's going to be an open plea and then reset for sentencing.
Is he
Yes,
here?
sir, I'm here. Okay, good.
All right, the criminal additions, Daniel Ramirez.
Yes, present, Your Honor.
All right, and what is- All right, what do we have to hear today?
It's a request for judicial clemency, Your Honor.
Okay. All right, and I believe all I had was the civil add-on, which is the writ. Is that correct? At
Yes, sir, that's scheduled for 2 o'clock today.
2 o'clock, okay. All right, anyone else told to be here today? Your case was not called. All right, give me just a moment.
Judge,
Yes.
I'm having trouble right now, so bear with me. On my other computer, my court reporting computer.
Okay. Take your time. Let us know when you're ready.
Okay, thanks.
All right, I'm going to make Miss Poppy the host so that she can take care of breakout rooms. And ask y'all to confer. I'm not going to be able to do pleas for a while. I need to wait for the Ms. Cavazos to get her stuff up and going.
Okay, Your Honor. I have to answer a Zoom docket in 186. Can I log off and then come back later?
Yes, sir.
All right,
I'll be
thank
here all
you.
day, looks like.
All right, thank you.
And Judge, this is Sean Hendrickson. I was having some technical difficulties, and so I missed docket call, but I am present for Christopher Perez.
Okay. And I think, was it Mr. Leday that I heard that with?
That's correct.
Represent the state. And did I think I asked you to see if you could find any more information from, does he have an attorney in his parole hearing?
No, he does not, Your Honor.
I'm sorry?
He does not.
Give me just a moment.
Your Honor, I think Dennis Braga just logged on.
Okay, I'll check with him in a moment. All right, and have you ever represented anyone in front of the, what is it, the Parole Commission?
I never have, Your Honor.
Here's what my thought, Mr. Henriksen, is that your client is in a very unfortunate position, but I don't know that Mr. Leday is not correct, that it's not the speedy trial that law or issues that have him there, it's the probation authority, the parole authorities. And especially if he's already served enough time to have completely fulfilled his underlying sentence, I don't see why they would still have a hold on him. Now, if that hold is preventing him from making bond in this case. But because even if, so what I'm going to do is ask you to either decide that you can't do that with the parole people, or I will appoint the public defender's office to represent him on his parole matter, just to get in touch with the parole authorities and say, look, if it wasn't for the parole hold, this guy would be out on a bond, waiting to stand trial for whatever it is he's charged with now. And if they have him in a catch-22 that he can't get out because he's on parole, but he's already served his parole sentence, they just don't want to terminate him because they don't know how to terminate him or something, then there ought to be some way you can get redress for that. But I'm not sure that the redress that he's would be entitled to would be a speedy trial dismissal on his new case. So is that something you want to work with the parole people on? Do you want me to appoint the public defender's office?
If you could appoint the public defender's office, I would appreciate that, since I haven't handled one of these issues before. Getting up to speed and everything may take a little bit of time.
Okay. Is there anybody at the public defender's office that has done parole hearings? Ought to be
Your
somebody.
Honor, this is Kathy. I have never done a parole hearing. Ryan Boyer might be familiar, and I don't know John's experience with it. I get what's the specific issue?
I'll let you get more detail, Mr. Henriksen, but we have an individual who has a new charge, and I say a new charge, it's been out for 18 months or something. He has served practically all and possibly every day of a 15-year sentence on robbery or aggravated robbery. But there's still a blue warrant hold on him, and so he cannot get out on the case that's pending. And if he has, I mean, if you look at it just as the issue of has his speedy trial rights being violated, well, then everybody who's being held who hasn't gotten a speedy trial because of COVID would be entitled to a speedy trial relief. And I'm not prepared to say that. But
it would clear your docket.
Well, but especially if he has, there'd be a lot less need for public defenders too if we didn't have any cases pending. So, but if it's just a matter of they need to have this case resolved and he's not ready to enter a plea to resolve it, then when he might talk to the state about dismiss it without prejudice and
then refile.
And then re-indict, or even say and have his agreement that he'd waive indictment and just let him file an information the next time. Okay. But that's just something y'all can discuss. But again, I'm not saying that I think that he's in a hard place, but it's not because of a speedy trial violation. It's because apparently if Mr. Henriksen, I mean, I know he hadn't gone to TDC and counted the days. If what Mr. Henriksen's being told by his client is correct, they're keeping on him after he's served his complete sentence. Okay. There ought to be a way to fix that.
Okay. Maybe before I do anything else, if I could get in a breakout room with Mr. Hendrickson, and if Janisha Davis could be put in there too. Sorry.
I have that when I have to have court from the house sometimes too. Kid's cat comes in. All right, so Ms. Cavazos, are you still working on your computer?
Yes, sir.
Okay, that's fine. Anything we can work on that we don't need a record for?
Judge, if I may,
Yes, sir.
I came in late on your docket on page 2, Steven Salinas, second one from the top. I don't see him on Zoom, and the numbers I have for him are no good. I just wanted to let the court know.
All right, give me a minute. My Acrobat is locked up. Yes, he did not appear.
I'll try his numbers again, Judge, but like I said, I haven't been able to get a hold of him.
All right, and Mr. Fraga has appeared?
Yes, sir. Yes, sir, I'm here.
Right. Okay, I'm going to continue. Well, all right. Let me know if we have something to work on that doesn't need a record, and we'll wait for Ms. Cavazos.
Your Honor, if I may, Nathan Slimane.
Yes, sir.
With reference to Gilbert Salinas, is an individual who didn't have the ability to get in this morning. Today was his first setting. Could I direct him to appear in a few days on March the 8th? Just have him go to the probation office.
Yes.
Would that be all right? And maybe excused to try to get in touch with him and give him that directive.
That's fine.
Thank you, Judge.
And Your Honor, David Marroquin, he's apparently trying to get in. He's not very tech savvy, apparently. So he'll be here shortly.
On the gentleman that just left, did he post a date for us, or what was that date again?
March 8th.
Your Honor, if I may, Sylvia Gonzalez for Cameron Matheson. I believe he's on. He was having some difficulties. Cameron, if you're on, can you unmute and let the judge know you're here? Okay, I'll keep checking, Judge.
Yes, yes. My name's Cameron Matheson. Hello.
Yes.
Yes, I'm here. I was having difficulties on how to do this phone thing. I'm sorry, but I'm here.
Okay, I'll mark you present.
Okay, we'll need to confer with the state, Your Honor. Thank you.
Okay, on the yes.
Who did she need to speak with of the state, Mark or Lorena?
With Lorena.
Okay, I'll put you guys in the breakout room.
Thank you.
And Your Honor, I do see Alma Suarez in here. She's on page 1 of the docket. Was marked absent to begin with.
All right.
My name is Alma Suarez, escort today.
All right, Ms. Poppy, you said that it was being reset or something?
I spoke with Ms. Carrillo yesterday if she needed an interpreter, and she told me no, that she'd be asking for a reset, and then I've asked her to get on ASAP.
All right, so please
So
hold
that's
on.
all I know, sir. Mr. Dominguez, on your client, Mr. Ortiz, is he in custody somewhere? I'm sorry, sir, I couldn't hear you.
He should be in probation, Jennifer.
Okay, can we get Mr. Ortiz at probation? Dimitri Ortiz, he would like to, his attorney would like to speak with him.
Right, Mr. Keendaws?
I still had to look at something for yours, Russell. So I had something I wanted to ask you about.
He went to another court. All right, who's representing the state on the Spalding case?
That's me, Judge.
Have you seen the discovery after it came back, or the plea papers rather, after they came back from Mr.?
Judge, once they go to us, they go to the clerk.
Okay, well, I did a lot of work cleaning them up because they're somewhat disheveled. I'm going to send a copy to you, and because I can't see where the page, the signature page for the prosecutor and the judge on the discovery certificate is in there.
Okay. Hi, good morning. My name is Alma Suarez. Escort for me today.
Yes, Ms. Suarez, we're
ma'am.
waiting for your attorney to come and set a date for you.
Un momento.
Is probation able to get Dimitri Ortiz?
Yes, sorry, Jennifer, I didn't hear you the first time. You want him in front of a computer?
Yes, his attorney's asking to speak with him.
Okay, sure. He'll be on the computer where it says defendant.
Okay, thank you very much.
No problem.
All right, Mr. Lede, are you on a cell phone or a tablet?
I'm on a cell phone.
Okay, I'm not able to send you documents in chat. I just sent Ms. Whitney a copy of the Spalding plea paperwork. It's just, I don't see, as I said, the page that we need for the signature page for the state and the judge on the discovery.
Okay, Judge, we'll look at it.
And Judge, I finished speaking with Ms. Starling about Christopher Perez's case.
Yes.
I think that what we may have decided on, and it's up to you, of course, that it may be better if they take over, I guess, the entire case, and then that way they can handle the parole issues as well as this current case.
That sounds good. If y'all will get me an order, I will sign it.
You want to do a motion to substitute counsel, Sean?
Yeah, I'll work on that.
Okay, and then instead of my name, if you just put Texas Rio Grande Legal Aid?
Okay.
Thank you.
Sure.
Your Honor, you said you sent me in chat the paperwork on Mr. Spalding.
Well,
that
I tried
correct?
to, but the little wheel is still spinning and it's only
Oh,
about
okay.
halfway done. So let me kill that and I'll just email it to both of y'all.
Okay.
Ms. Carrillo is here now.
Excellent.
Lorena, are you there?
Yes, ma'am, I'm here.
Okay, so you mentioned we have a reset date on Bethany Hinojosa, whose son passed away. Is there a specific date?
Yes, ma'am. Let me pull it up. It's in my email.
3/24, Miss Lorena.
Thank you, Jennifer.
You're welcome.
Thank you.
Judge, the state and I have agreed to a reset on Cameron Matheson. May we be excused?
Okay, for all the attorneys, as long as there's nothing for me to resolve, like you and the state can't come to an agreement on dates, once you have for sure for all of your cases posted to me in chat in the cause number, name, date format, the new dates, you're excused, your clients too.
And Judge, can we mention, if they're in custody somewhere else, they still need a date for our court, because last setting, quite a few attorneys left without posting dates.
Yes, everybody, unless you've got a special dispensation, you're not finished until we have a new date for your client. Now, if they already have other dates, that's fine, but never leave court without a date for your client.
Your Honor,
Yes, ma'am.
I'm sorry I'm late, but I have excuse me. I have two people, I believe. Number 19, Alma Arroyo Juarez, which is on page 1. And I don't know, she was having problems logging in. That's a
She's
trial.
good.
There's a trial case, Your Honor. So, need a trial date on that.
I'll repost the dates, Nifa.
Oh, okay. On chat?
Yes, if you join late, you can't see them, so I'm going to repost them to everybody.
I appreciate it. Thank you. And then I have Mr. Joe Luke Sanchez. He's got like 5 cases.
Yes.
It's also a trial case.
Okay, just send me in chat his new dates and the cause
Yes, Your
number, name, date format, and your excuse.
Yes, Your Honor. I believe that's all I have on today's log. If I find something else, I'll log back in, Your Honor.
All right, thank you.
Thank you.
Does she need to speak with her client that was having a hard time understanding us?
Oh yeah, she's a Spanish speaker. I didn't order an interpreter, so if I could speak to her, Señora Alma.
Sí.
I'll put you in a breakout room.
Sí.
Thank you. Well, just let me tell her really quick and she can log off. Okay.
Okay.
Señora Alma, ya se puede retirar del programa. Ya tenemos otra fecha, solo que yo hablo con usted por el teléfono. ¿Está bien?
Muchísimas gracias, muy amable.
Okay. Ya se puede retirar.
Gracias.
Thank you, Your Honor.
And Your Honor, I'm sorry to bother you. I was in another court. I'm present. We have a motion for judicial clemency on Daniel Ramirez. Whenever the court's ready for us, I've conferred with the state. We're ready on that.
All right, if the clerk's office would just bring me the file.
And Judge, on the Spalding matter, the paperwork that you sent is not as it went out.
I know, I understand that. It's a mess. It's been reformatted, jumbled mess.
I apologize for that, Your Honor. The UPS store where I had it printed out, they chopped it all up. It was hard for me to read through with my attorney as well.
And Judge, if I may, I think I can pull out the page that has your signature line and my signature line and include it. Mr. King Dawes and Mr. Spalding have already signed. So theirs would be blank on it, but we would have space for ours. Would that be amenable?
Yes.
Okay.
All right, give me just a minute. Look at the Ramirez case.
Mr. Dominguez, are you needing to speak with Mark or Lorena?
Lorena, please.
Okay. Mr. Nitz, Mr. Marroquin is joining right now. His audio is still connecting.
And Your Honor, that'll just be a reset to 5-3 when he gets on.
All right, Mr. Spalding, what sort of computer are you on? Is it a telephone or
I'm
what is it?
on my cell phone, yes, sir.
Judge, I'm ready when you are. I'm just, I haven't gotten it fixed, but I've got an alternate source, another source. So I'll be.
Just a moment. Okay. Who do we have with a plea that doesn't have Sean Keendaws for a lawyer?
Your Honor, I have two in probation and waiting.
I have one. All right, Ms. Lambert spoke up first, and they are?
Christopher Houghton and Gabriela Mendoza.
Okay, I have the Gabriela Mendoza papers and get rid of some of this stuff here.
Probation.
I have Miss Mendoza in my office right now. We're still going over her judgment, and I'm still completing her PSI.
Okay. And Christopher Houghton is the same, or neither of them ready?
None of them are ready right now. All the officers are working on their PSIs and judgments.
Never mind, Your Honor. I'm sorry.
Okay, well, let me go and
Your Honor, we may be ready on Sergio Diaz. I don't know the state with probation, but he should be there.
And Your Honor, if me and Janisha from Chala can be put in a breakout room with.
Okay, I'm not the host. I'm not doing that. That's Miss Poppy.
Jennifer, I'll chat you.
Yes, ma'am.
Okay. I see it now. Your Honor, we're working on all the pleas right now, doing the paperwork with them. Diaz is in our office right now.
Okay.
Thank you.
Your Honor, I believe that David Markin's audio is on.
Okay.
Maybe be excused.
Yeah, look it over.
All right, hold on. Okay. I have no idea. If there's no dispute between the state and the defense, and if you have posted his next court date from the selections offered up by the coordinator's office, then he is excused and should be excused without further inquiry.
Okay, I apologize. I didn't know if you wanted to have him verbally announce.
No, because again, I'm not going back and double checking y'all's work at this point and making sure that you really did post something and that you really did post a date that was given to by the clerk. By the coordinator. If we find out that's not what's going on, then we'll follow up on it. But
thank you, Your Honor.
Your Honor, if I may.
No, sir, you have an attorney. You need to keep your computer muted.
this for me, or I'm ready to know. Let's go.
Mr. Cedillos, are you addressing me?
No, Your Honor, I'm sorry.
From all this right now, or?
Okay, so let me know when we have someone that's ready on a plea.
Your Honor, defense is prepared for the plea on Deirdre Silva if someone from the state is available.
Okay, where's Ms. Silva?
She is with probation.
Okay, have they finished with her?
Your Honor, it's a motion to revoke, Your Honor. They do not need to go over anything with her.
And that was my understanding as well, Your Honor.
So give me a minute.
Thank you, Judge.
At the jail, if we could have Albert Arguri, we would appreciate it for room 5.
Okay, let me get him. Stand by.
Thank you.
What is wrong with crap my computer? Your Honor, I have a motion to withdraw as counsel on the Douglas Luckbaum case. Do you want me to forward that on to you or push it through in e-file?
Why don't you go ahead and forward that on to me?
And Judge, I drafted that motion to substitute on Christopher Perez's case. How would you like me to get that to you, Your Honor?
Post it in chat is good.
And as PDF or Word, which works better for you?
PDF.
Okay, thank you.
Okay. So who are we ready on that it's an MTR or motion to adjudicate?
Deidre Silva, Your Honor.
right, calling State versus Deidre Silva. Are both sides ready?
State is ready to proceed, Your Honor. She should be at probation.
Yes, and defense is ready. I believe she is there at probation.
Well, let's see if my computer resumes working. All right, where is Deidre Silva?
She should be at the probation office, Your Honor. If we just need confirmation, or I don't know if maybe the computer that was at probation was still being used by somebody in a breakout room. I think I heard that earlier.
All right, it could be. Well, let me know when we have something that's ready to go.
So we are needing at probation because the defendant computer just came back with us.
Deidre Silva.
And I think that may be her now, Your Honor.
Okay, are you Deidre Silva?
Yes, sir.
Okay. Is that your, okay. And, all right, so now everyone's ready to proceed, yes?
State's ready to proceed, Your Honor.
Defense is ready, Your Honor.
Okay. Are you the same Deidre Silva who was placed on 5 years probation with an underlying sentence of 5 years on or about September 27th, 2017 for the offense of organized criminal activity?
Yes, sir.
Okay, and let me ask the state, what degree of offense was that?
It's a 3rd degree, Your Honor.
Okay. All right, ma'am. And you understand that on that day you were found guilty and you were given an underlying sentence of 5 years in prison. Now, the state has alleged that you have violated it, but you were not sent to prison. You were instead placed on probation for a term of 5 years. Now, the state has alleged that you have violated the terms of your probation. If they can show that that's true, then you could be found, then you could be have your probation revoked and you could be sentenced to anything of not less than 2 years, which is the minimum period of incarceration for a 3rd degree felony, and not more than 5 years, which is the period of time that you have been sentenced to. And you could also be sentenced to any unpaid portion of a fine that was previously imposed.
Yes, sir.
Now, the state has alleged that you violated rule number 11 of your probation. Specifically, the state's allegation is that you failed to report to your probation officer in November and December of 2017, in February through December of 2018, in the entire year of 2019, and in January through October of 2020. So do you understand what it is the state's alleging that you did wrong?
Yes.
Right. You understand the plea bargain agreement you have with the state is not binding on me. I don't have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
Yes, sir.
And if I do follow the plea bargain that you have with the state, you will not be able to appeal this matter without my, you will not be able to appeal this matter. Do you understand that?
Yes, sir.
Right, I want to show you some documents that appear to have your signature. They're titled Written Waiver and Consent to Stipulation of Testimony. And let me ask on these, Can you speak, read, and write the English language?
Yes, sir.
Okay. All right, so on page 3, I want to ask you, do you swear or affirm that everything that appears above your signature on page 3 is true and correct?
Yes, sir.
And is that your signature?
Yes, sir.
Okay, and did you also sign on the plea bargain agreement?
Yes, sir.
Waiver of time to file motion for new trial?
Yes, sir.
Court certification of appeal?
Yes, sir.
All right. Did you read these documents yourself, or did your attorney read them to you before you signed them?
Yes.
Okay. And are you satisfied with the work your attorney has done for you?
Yes, I am.
Okay. Counsel, do you believe your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
Yes, Your Honor.
Okay. All right, then. I'll find that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I will ask you, to the allegation that you violated Rule 11 of your probation by failing to report your probation officer, is that true or not true?
It's true.
Okay. All right, I'll accept your plea of true and ask what evidence the state has to substantiate the defendant's violation.
Your Honor, at this time, state would offer State's Exhibit 1 and its attachments.
No objection, Your Honor.
All right, without objection, State's Exhibit 1 and its attachments are admitted into evidence. Do both sides rest and close at guilt innocence?
State rest and closes, Your Honor.
I mean, at this stage, I'm sorry.
Defense.
Okay. Okay, I'll find there is enough evidence to substantiate the violation. I'll also find that a change needs to be made in the disposition in this case. So I'll ask, are both sides ready for that hearing?
State's ready to proceed.
Defense is ready, Your Honor.
Has there been a precedence investigation or a waiver of one?
But I believe Ms. Silva waived the precedence investigation in this case, Your Honor.
Okay.
For the agreement.
So there's been a waiver of it?
Yes, Your Honor.
Okay. All right. What is the plea bargain agreement in this case?
Your Honor, at this time, we're asking that Ms. Silva's probation be revoked, that she be confined in the Texas Department of Criminal Justice for a term of 3 years, that she pay the court costs in the amount of $214, a fine in the amount of $2,000, and that she paid $50 Crime Stoppers fee. We also ask that she be given credit for time that she's already served. We show 10 days worth of credit.
All right, ma'am, you heard what was read in the record by the state's attorney. Is that your agreement with the state?
Yes.
Did the state's attorney add anything or leave anything out?
No, sir.
Okay. All right, then. Anything else on either side?
Nothing further from the state, Your Honor.
Yes, Your Honor. If I may ask.
Mr. Moreno, you're breaking up.
To run the fines. I'm sorry, let me change my internet settings. Is that better, Your Honor?
Yes.
The defense would ask if the court is willing to allow for the fines and the court costs and the crime cyber fee to be run concurrent with the sentence.
All right. Was there a fine?
There was a fine, Your Honor, of $2,000.
All right. Does Ms. Silva have any dependents?
Do I have dependents?
Yes.
Yes, sir, I have 4.
All right, I'll run the time and money concurrently.
Thank you.
Thank you, Your Honor.
All right, ma'am. You've previously been found guilty of the third-degree felony offense of organized criminal activity. At this time, I will revoke your probation. I will follow the plea bargain agreement, and I will sentence you to 3 years confinement plus the unpaid portion of your court cost and fine with the time and money to run concurrently. Is there any legal reason why a sentence should not now be imposed?
No, Your Honor.
All right, it is the order, judgment, decree of the court that you be taken by the sheriff of Wilson County and transported to the authorized receiving agent of the Department of Criminal Justice. We can find for a period of 3 years. Your sentence will commence today. You'll receive credit for all the time you have spent so far in jail on this charge. That being, was it 10 days?
That is correct, Your Honor.
That being 10 days. Okay. All right. You understand, ma'am, that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes, sir.
All right. I'll find you made your post-trial waivers knowingly, intelligently, and voluntarily also, and I will approve them. And I will certify to the Court of Appeals that this is a plea bargain case and you waived the right to appeal so that you may not appeal. I wish you good luck, ma'am.
Thank you, sir.
I used to office in the same tower you're in, Mr. Moreno, and people would see that 112 East Pecan and they think that we were like in an old White House out in the suburbs with leafy trees all around. Okay, so I've got that done. I now got the judgment, and I'm going to get
Finished.
we're going to get fingerprints there at probation or what?
I have her fingerprint, Your Honor, and the bailiffs are on their way to take her into custody.
You have anything on you?
I just have money and paper.
Paper, that's it.
All right, and let me post these to Ms. Sawyer's. Okay, and they went through, hopefully. All right, and on the Daniel Ramirez, Mr. Barrera, I'm sorry, I got distracted.
Not a problem, Your Honor.
Your Honor, there was an attachment A, I believe, that I sent you as well that needed your signature. Did you add that to the packet or judgment?
Well, I ran the time and money concurrently, so do you still need it? Actually, I guess I need to change the judgment. Hold on. Okay, where would it be appropriate to edit the judgment to say time and money concurrently? Should I just put as to time and money where it says the Senate shall run concurrent? Anyone, Bueller?
Your Honor, I think that may be the best place to.
Okay.
So my question on the attachment A, Your Honor, then would be, is it just the fine or is it, I mean, the court costs we do need to get collected. And so that would change the amount on attachment A just to the 214 if you're going to run the fine concurrent with her time.
All right, let me just make it the fine, just the time and fine.
And that's fine, Your Honor.
It's not
Thank you.
much. All right, so. Okay, so what would it be, $264?
Yeah, so that would be the court cost and the Crime Stoppers fee if we're going to include the Crime Stoppers with court cost.
All right, let me edit this.
Also, Your Honor, on the plea packet, I am missing your signature on page 3 of the plea packet. Does it need to be signed there?
All right, let me come back and look.
Tom Caldwell just said he's sick. He's on the so he apologized because he's working a little slow pulling stuff up for judge. And he said, I'm sick with COVID right now. And Grace was on, but Grace wasn't in the office. She was, looks like she was at her home. So
And on page 4, Your Honor.
All right, I must have sent it before I hit save.
His signature's not on any of them. He's re-signing it.
He's re-signing it?
Yeah, his signature's not on anything. It's just dated.
Yeah, I must have sent it before I hit save because it's all on my copy. Let me resend that.
And Your Honor,
Yes.
while we have a second, we checked on the in custody of those two defendants that were in custody in other counties, and neither one are in custody in either county. On page 4, second down, Daniel Gibson is not in federal custody or state custody in DeWitt County or anyplace else in the state. Mr. Jones, who is on page 6, was released from custody yesterday. So out of El Paso. So I'm not sure if he had notice to be to log in this morning for us, but he was in custody until yesterday.
And Your Honor, Mr. Jones, I have not been in contact with him personally, but I have spoken with his wife. I'm going to be giving her a call right now to try to get a hold of him.
All right, I mean, he needs to be here, but we can set him one time for next week because he would have had to leave at midnight to be here or before. So let me look at this.
I'll get a reset date for next week then, Your Honor.
Okay. All right. So State versus Daniel Ramirez.
Yes, Your Honor.
Right. Look at your motion.
Ms. Whitney, if you're available, Mr. Dominguez wanted to see you in room 7 again.
Jennifer, I am available. Who wants to speak with me?
Mr. Dominguez?
Okay.
Go ahead, Mr. Barrera.
Your Honor, we appeared in this court on February 2nd to file a motion for early termination. Mr. Ramirez was on regular probation where he took a conviction on his case for possession of a controlled substance. It is a first-degree felony. The situation is that we're asking the court to grant judicial clemency, which would essentially place Mr. Ramirez in the same position he would be in if he had received deferred adjudication. And the reason for that is that Mr. Ramirez has a relatively clean record. He successfully completed his probation. He has 2 daughters, a 4-year-old and a 1-year-old, and he's in a position where he would like to join the military. That is not possible with a felony conviction on his record. It may not be possible even with judicial clemency, but at least it gives him an opportunity. So we're not asking that he be put in a position where this case can be expunged. My understanding is that even with judicial clemency, you're in a situation similar to a deferred, where the case cannot be removed from your record, but we're asking that at least he be allowed to be in a position where he is no longer a convicted felon. He successfully completed his probation. He has not picked up any new cases, and he is trying to move on with his life and support his family. Given that he's already successfully completed this, he wants the opportunity to join the armed forces, or at a minimum, obtain a good job to support his kids. This was a one-time drug offense that was a bad decision on his part. And so we're just asking the court to give him a second chance to be able to move on with his life, Judge, without this conviction following him around for the rest of his life.
Okay, and what says the state?
Judge, what Mr. Barrera said is true. In fact, Mr. Ramirez has completed his probation early. Our only argument that we would offer, Judge, is just the nature of the crime, which is degree of felony, which is a first-degree felony. That might be a little high to grant clemency.
Mr. Ramirez, would you raise your right hand? Do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You can put your hand down. And I'm trying to stop it from screen sharing. But it won't do it. Okay. All right, sir. What branch of the service are you looking at joining?
The Army, sir.
Okay. And which recruiter have you been talking to?
The last recruiter I spoke to was like in 2019. It was Sergeant Vasquez. But at that time, I went to court in July of 2019 in CE, matter of fact, because I had the same issue that I couldn't. The recruiter didn't want to move forward with me, do no ASVAB, do no training unless he knew that I wasn't a convicted felon. So when I went to court in July, the summer of July, to go see whatever, it got the motion got revoked. So I let him know what happened, and I told him that that we had scheduled for next again. And he said, just keep your head up, just keep trying again, and we'll retry. And whenever you're ready, come speak to me again. But like from my understanding is that, as long as you're a felon, you can't join any service, like any branch, like whatever whether it be a small felony or a big felony, they just won't let you in as a felon, as a convicted felon.
It goes up and down, but yes, sir, that's my understanding. And we're not in a big war. All right. I'll take you at your word, Mr. Ramirez. I always say what I want down the road as a taxpayer. I was a prosecutor in misdemeanor level, which is much lower level, for quite a while. One of the first cases I had where I gave somebody a chance that did pay off. It was about as brutal of a beating as you could give somebody without it being a felony. But I dismissed the case. So the guy didn't have a probation for a violent crime, and he went in the Marine Corps. And I didn't see him for a number of years. The next time I saw him was at a social event with his sergeant stripes and his, Marine Corps blues, and that paid off. They don't always. So I will sign the motion for judicial clemency. If somebody will prepare an order.
Thank you, Your Honor.
I'll have an order prepared and sent over to you, Judge.
Your Honor, I believe I sent an order to you with the motion this morning in an email.
Okay, I'll go and look. Actually, I'm going to need to. Okay, I'm going to leave and come back. I hit to spotlight the video like I always do, but now I've got a big blank or big white block in my computer, and I can see just one person at a time. Let me try to change this around. Yeah, no, it's messed up. Okay, I'm going to leave the meeting. I'll be right back.
Lorena, Mr. Perez wants to speak with you in breakout room 7, please. Judge, it did make you the host, so right now you're the host and I have no other abilities, okay?
I have received everything from probation now. I think they are finished with both Gabriela Mendoza and Sergio Diaz, and we're ready to go on either one of those.
Okay, now can people hear me? Anyone? Yes.
I can hear you, Judge.
Okay.
I hear you.
It just every week, if not every day, it does something it's never done before. All right, so do we have any other, oh, wait, I need for the order on Ramirez.
Your Honor,
Yes.
Dennis Fraga wants to address the court. He wants to retain another attorney.
All right, are you retained or appointed, Mr. Cedios?
I'm appointed, Your Honor.
All right, where is Mr. Fraga?
I'm right here, Judge.
All right. And what do you want to relate to me, Mr. Fraga?
Well, throughout the case, I wanted to see if I could retain my own lawyer. I think I would get better choices if I had to retain my own lawyer.
All right, now, Mr. Fraga, you had a court-appointed attorney because you'd represented to the court that you couldn't afford your own attorney. Now, things change, especially when we're not going to trial. So if you have the money to hire your own attorney, that attorney can file a notice of appearance of retained counsel any day that the clerk's office is open, which is 24/7 on with computers.
Okay.
And either Judge Ellison or myself will sign that order.
Yes, sir.
Making that attorney your attorney. Until then, Mr. Cedios is your attorney.
Yes, sir.
Okay?
Okay.
Your Honor, should I post a reset date?
Please.
Okay, I'll do that.
Judge, on concerns, I put that motion in chat for you, the motion to substitute counsel.
Okay, well, you're gonna need to redo it because I had to leave the meeting due to technical difficulties.
I will repost it.
Yeah, those things all go away when you do that.
Your Honor, when you have a moment, I have an announcement.
All right, give me just a moment.
Is there any way we could have Mr. Ortiz back at probation to speak with his attorney?
Sorry, what?
Mr. Ortiz, can we have him back in front of the computer to speak with the attorney Dominguez?
Yes, just 1 second.
Thank you.
All right, yes, Mr. Briggs.
Yes, Your Honor. My client, Rogelio Tellez, he's at the bottom of page 3 of the docket, was not previously present. He is in the meeting now under the name of Rogers Galaxy A11, I believe. And I just want the court to acknowledge his presence so I can go ahead and post a reset. Mr. Tellez, can you unmute and speak up, please?
All right, Mr. Tellez.
Yes.
Okay, you're Rogelio Tellez?
Yes, sir.
All right, Mr. Tellez.
Yes.
You need to be online at 9 a.m. next time. And on one
Yes, sir.
device, not two. Okay?
Okay.
Go ahead, Mr. Briggs.
Thank you, Your Honor.
Okay, so we have anybody else ready for a plea?
Your Honor,
Yes.
Mara Moreno. I'm present as well on a sentencing today for Jose Rios. I'm assuming we are needing somebody from probation on that sentencing. So I'm not, I believe it might take some time before we get to that point. Is it okay if I step away and conduct another Zoom hearing here in Bexar County and then come back into your courtroom?
Sure.
Thank you, Judge.
All right,
Jennifer,
so do we have
that's
anything
Miss-
ready to go?
I believe Christopher Houghton's documents have been sent to you, Your Honor.
Jennifer, that's Mr. Ortiz. It says defendant.
Okay, yes.
Thank you. Judge Wilson, you're not needing Mr. Daniel Ramirez anymore on that clemency hearing, correct? You're done?
Right.
Okay.
All right, Ms. Saunders, I just posted the motion and signed order on Christopher Perez to you to substitute TRLA.
Thank you.
Received.
Okay, and I'm sorry. Who do we have next who is cleared probation, everything else?
I have Gabriela Mendoza and Sergio Diaz have both been completed. Are y'all finished with Dimitri Ortiz yet, Andrew? Or somebody in probation?
I'm sorry, who do we need?
Gabriela Mendoza, Andrew.
Just 1 second. We have Mr. Ortiz talking to his attorney in our room.
Okay.
I believe they're back. We just got back.
Just fax it to booking? Is that? Yes, booking's wanting a copy to get her booked in.
Okay.
Okay, so Ortiz and Mendoza. Ready to go?
I'm sorry, Your Honor, which case are we discussing?
I'm asking, ready to go on?
Gabriela Mendoza, Your Honor.
Yes, Your Honor. She's there at the probation.
Yeah, I'm here.
Let's get Ms. Mendoza just because I received those papers first.
We're ready, Your Honor. She's there in the probation.
Morning, Your Honor.
Okay, calling CRW 20-05-109, State versus Gabriela Mendoza. Are both sides ready?
State's ready to proceed, Your Honor.
Vince is ready, Your Honor.
Okay. Are you Gabriela Mendoza?
Yes, Your Honor.
Is that your true and correct name?
Yes.
All right, Ms. Mendoza, can you speak, read, and write the English language?
Yes.
Are you a United States citizen?
Yes.
Okay. Despite your representation that you are a United States citizen, I need to caution you that any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you
Yes, I'm
stand
right.
to enter a plea today?
Yes.
Do you have any history of mental health problems or mental illness?
No, sir.
Counsel, do you believe your client is competent to stand trial?
I do, Your Honor.
All right, man. You stand charged by indictment with the state jail felony offense of possession of a controlled substance. Specifically, it's alleged that here in Wilson County, on or about November 27th, 2019, you intentionally or knowingly possessed a controlled substance, methamphetamine, in an amount of less than 1 gram. That alleges, as I said, a state jail felony, which is punishable by confinement for not less than 180 days and not more than 2 years. and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, sir, I do.
Okay. Do you understand that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
Yes,
You understand also that if I do follow the plea bargain agreement in this case, and the sentence I impose is not harder on you than what you have agreed to, you will not be able to appeal this matter without my, you will not be able to appeal this matter.
yes,
And you understand also that if your plea bargain agreement is for deferred adjudication probation, and I decide to follow it, I will find there's enough evidence to say you're guilty, but I will not do so. Instead, I will defer or put off a finding of guilt and place you on deferred adjudication probation. And if you successfully complete that deferred adjudication probation, the case against you will be dismissed, you'll have no conviction, and you may be able to get an order of non-disclosure to keep the state from telling anyone other than law enforcement that you were even arrested in this case. However, if, on the other hand, while you're on deferred adjudication probation, the state alleges that you violated the terms of that deferred adjudication, then you could be arrested, you could be brought back to court, and there would be a hearing on just that issue. Did you violate the rules? And if the answer to that turns out to be yes, then you could be found guilty and sentenced to anything that's a legal sentence for a state jail felon. That is from 180 days to 2 years confinement and a fine up to $10,000.
yes, I'm aware.
I'm sorry?
I said I am aware of like the consequences and everything. Or
You're aware. Okay, all right, thank you. All right, I'm going to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Plea to the Court. And let me ask, here on paragraph 2.11, is that your signature?
yes, sir.
And on the next page where it says verification.
Yes, that is my signature.
And do you swear or affirm to me and to the district clerk's office that everything that appears above your signature is true and correct?
Yes, sir.
All right. Did you also sign on the certification of appeal?
Yes, sir.
Agreed punishment?
Yes,
Waiver of preservation of evidence?
yes, sir.
On page 2 of the discovery compliance certificate. Right down here.
Yes, sir. Yes.
All right. Did you read these documents yourself or did your attorney read them to you?
Yes, we did discuss it before me signing it.
All right. Well, did you understand these documents before you signed them?
Yes, sir. He answered every question I had.
All right. And are you satisfied with the work that Mr. Lambert has done for you?
Yes, sir. He's explained everything to me.
All right, counsel, do you believe your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
Your Honor, she has a rational understanding of the charges being leveled against her, and I believe she is competent and ready to move forward.
Does she understand all the rights she's giving up and the stipulations of evidence she's making?
She does, Your Honor.
Okay. All right, and do you believe you've received all the discovery you're entitled to in a timely manner?
I have, Your Honor.
All right, I will accept the discovery compliance certificate and I will find that the defendant made her waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I will ask you, ma'am, to the allegation in the indictment, state jail felony, possession of a controlled substance, do you plead guilty or not guilty?
I'm pleading a no contest.
We spoke about this. If we want the deferred adjudication, we have to plead.
Okay, ma'am.
Guilty.
Okay. All right. So has anyone promised you anything other than your plea bargain agreement with the state to get you to plead guilty?
No, sir.
Has anyone harmed or threatened you or anyone close to you to get you to enter your plea?
No, sir.
Has anyone promised you an early release from your sentence?
No.
All right, I'll find that you made your plea voluntarily. You're under any compulsion in making it, and I will accept it. I'll ask what evidence the state has to substantiate the defendant's guilt.
Your Honor, at this time, state would offer State's Exhibit 1 and its attachments.
We have received that, Your Honor, and reviewed it. No objections.
Without objection, State's Exhibit 1 and its attachments are admitted into evidence. Both sides rest and close at this stage.
State rest and closes, Your Honor.
Defense rests and closes, Your Honor.
Give me just a. Give me a moment. My computer's locked up. Let's give it a bit. Or I'll find there is enough evidence to substantiate the defendant's guilt. Are both sides ready for sentencing?
State's ready to proceed, Your Honor.
This is ready, Your Honor.
All right, I've been given a pre-sentence investigation. Is that this case? No.
Yes, Your Honor. I received a copy of it.
Sarah said she was going to send me one. I have not received a copy, but
Here it is.
Lorena will send me one, I'm sure, afterwards.
Well, you need to get a chance to look at it with your client.
I haven't gotten anything returned back, Philip, but I CC'd you in the same email with Lorena and Judge Wilson.
I can forward it to you real quick, Philip.
Right, thanks.
Yeah, I'm not seeing it. Thank you.
Yeah, I just sent it.
It might be in your spam also. You might want to check your spam.
I received the Lorena's copy.
Okay. Let me know when you've had a chance to review it, if you have any objections to it.
Your Honor, no objections. They've pretty much added everything that we originally agreed on: deferred adjudication, community service, and drug testing.
Okay, what is the plea bargain agreement in this case?
Your Honor, at this time, we're asking that the defendant be placed on 3 years deferred adjudication, that she pay a fine of $1,500, Crime Stoppers fee of $50, that she perform 200 hours of community service, that she attend and complete the drug offender education program, that she follow the standard drug offender conditions, that she pay a drug test fee of $50, that she undergo a drug and alcohol evaluation and follow those recommendations, pay a monthly probation fee of $60, restitution in the amount of $60, court cost fee of $290, and a police officer fee of $5.
That is our understanding as well, Your Honor. No objections.
All right, ma'am, did you hear what was read in the record by the state's attorney?
Yes.
Is that your agreement?
Yes, sir.
Was there anything that the state's attorney added or left out?
No, everything she read sounded about right.
Okay, and anything else from either side?
Nothing further, Your Honor. Our judgment reflected that she was going to plead no contest. We will fix that and get that sent to the court, Your Honor.
I can make that change. That's fine.
We had guilty on our side, I thought, but no changes, Your Honor. Nothing else from the defense.
All right, ma'am, when you are employed, what sort of work do you do?
Pretty much, I've done security. I've done worked at a junkyard. That's pretty much what I'm familiar with and what I plan on going back to. So.
What did you do in a junkyard?
I sold car parts. Also removed car parts for some people. And
Okay, I worked for I-10 Auto Parts the summer before I went to law school. That was my job. I was working in
love it.
in track of all the parts and also part-time going out and pulling them off and bringing them up to the front and stuff. All right. Okay, then I will follow the plea bargain agreement in this case. I'll find there's enough evidence to say that the defendant is guilty, but I will not find her guilty. Instead, I will place her on deferred adjudication probation for a period of 3 years with all the rest of the terms and conditions of her plea bargain agreement with the state. I need you to keep in mind, ma'am, that if you do everything you're supposed to do, the case against you will be dismissed. But if the state alleges that you're breaking the rules, then you could be arrested, you could be brought back to court, and there would be a hearing on just that issue. Are you breaking the rules? And if it turns out that you are breaking the rules, then you could be found guilty and sentenced to anything that's a legal sentence for a state jail felony, 180 days to 2 years confinement and a fine up to $10,000. The other thing I want to tell you is that in this judicial district, as long as you're doing everything else you're supposed to be doing, we're not going to run out and have you adjudicated guilty just because you're not making 100% of your payments on time. It is important that you pay all the money you're supposed to pay, but if absolutely necessary, we can let you make larger payments towards the end of the 3 years or even extend you. So if a month rolls around where you can't make a payment, don't fail to go and see your probation officer because you don't want to go and tell them you don't have the money. So you understand that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes, sir.
Okay, I'll find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will post them or approve them. And I will certify to the Court of Appeals that you've waived the right to appeal and you may not appeal. I wish you good luck.
Thank you, Your Honor. Can Gabriella be dismissed?
Yes. Well, I mean, they need a fingerprint thumbprint somewhere.
Gabriella, give me a call whenever you get out, okay?
Okay.
Thank you.
All right, and give me just a moment.
Ms. Poppy, when you get a chance, could I talk to probation? And if they're super busy, Christopher Pettis in the jail, I can also talk to him.
My question to you would be, do you want to talk to Mr. Flores or who exactly?
Mr. Flores would be great.
I'm available.
Okay, I'll put you in a breakout room now.
Thank you. Can you add Janisha as well? Thanks.
Okay, let me try to get this to Ms. Sawyers. I've never seen this before. Acrobat wouldn't let me sign the verification part of the Mendoza plea package. I would try to put my signature on there or type onto it, and everything would just disappear. And I redacted that whole part of the document in case there was some sort of bizarre message command there, and it would just disappear. I had to print it to a PDF. All right, who's next?
Sergio Diaz.
Okay, and who's on a cell phone that has the name The Matrix? I'm asking you to unmute. Yes, sir. What's your name?
Stephen Salinas, sir. Can you hear me? I don't know how to use this.
Yes.
I've been learning just today.
All right, Mr. Salinas, I'll mark you present.
Thank you, sir.
Okay, I'm sorry. Ortiz is next.
Diaz. Sergio.
Sergio Diaz.
And I just sent his PSI to Lorena, to you, Your Honor, and to the attorney.
Okay.
I've got it, Judge.
All right, calling State versus Sergio Diaz. Are both sides ready?
State's ready, Judge.
Defense is ready, Your Honor.
Okay, and where is Mr. Diaz?
Probation, Your Honor.
Okay, well, I need him on the screen. Right, is the defendant computer in probation, is that in a breakout room?
No, sir, I think the defendant computer has lost connection. Here, they come back in right now. I'm admitting them.
Okay.
They're connecting to audio now.
Okay, Judge, here's Mr. Diaz.
Okay, are you Sergio Diaz?
Yes, sir.
Is that your true and correct, Sergio Rene Diaz?
Yes.
Is that your true and correct name?
Yes, sir. Yes, Your Honor.
All right. Mr. Diaz, can you speak, read, and write the English language?
I sure can.
And are you a United States citizen?
Yes, I am.
All right, despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes.
Do you have any history of mental health problems or mental illness?
No, I do not, Your Honor.
All right, counsel, do you believe your client's competent to stand trial?
I do, Your Honor.
All right. Mr. Diaz, do you understand that you are charged by indictment with, hold on, my computer's locking up, a state jail felony offense of possession of a controlled substance? Specifically, it's alleged that here in Wilson County, on or about August the 1st, 2019, that you intentionally or knowingly possessed a controlled substance, a material, compound, mixture, or preparation in an amount of less than 1 gram that contained a quantity of delta-9 tetrahydrocannabinol. That alleges a state jail felony, which, as I said, and that is punishable in Texas by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, Your Honor.
You understand, sir, that the plea bargain agreement you have worked out with the state is not binding on me. I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
No, I enter my guilty. Guilty.
Okay, no, sir. What I'm saying is I don't have to follow the plea bargain you've worked out with the state. Okay. Whatever you've come up with, I can enter a sentence that says something entirely different. But if I do that, you will have an opportunity to take your plea back. Do you understand that?
Oh, yes, sir. I'm sorry. Yes, sir.
You understand also that if I don't do that, if the sentence I impose is not harder on you than what you have agreed to, do you understand that you will not be able to appeal this matter?
Yes. Yes, Your Honor.
All right. And do you understand that if your plea bargain agreement is for deferred adjudication probation and I was to follow it, I would find that there was enough evidence to say you were guilty, but I would not do so. Instead, I would place you on deferred adjudication probation and defer or put off any finding of guilt. And if you successfully complete that deferred adjudication probation, then the case against you will be dismissed. You'll have no conviction, and you might even be able to get an order of non-disclosure to keep the state from telling anyone other than law enforcement that you were even arrested in this case. However, the flip side of that is that if, while you're on deferred adjudication, if the state alleges that you've broken the rules, then you could be arrested, you could be brought back to court, and it would be a hearing on just that question. Did you break the rules? And if the answer to that turns out to be yes, then you could be found guilty and you could be sentenced to anything that's a legal sentence for a state jail felony. That is 180 days to 2 years confinement and a fine up to $10,000. So do you understand all that?
Yes, I do, Your Honor.
All right, I want to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Plea to the Court. And let me ask, on paragraph 2.11, is that your signature?
Yes, it is, Your Honor.
Okay. And also on page 5 where it says verification.
Yes, that is my signature, Your Honor.
And do you swear or affirm that everything above where it says verification is true and correct?
Yes, I do, Your Honor.
And do you also sign at the certification of appeal?
Yes, Your Honor.
Waiver of preservation of evidence
Yes, Your Honor.
and discovery compliance certificate.
Yes, Your Honor.
Did you read these documents yourself, or did your attorney, Mr. Villa, read them to you?
Me and Mr. Villa had a meeting and we went over all the documents together.
Okay. Did you understand these documents before you signed them?
Yes, I did.
And are you satisfied with the work your attorney has done for you?
Yes, I am.
Counsel, first of all, do you believe you've received all the discovery you're entitled to in a timely manner?
Yes, Your Honor.
And do you also believe your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain with the state?
Yes, Your Honor.
All right. I will find, sir, that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I will accept and approve them, and I will also accept the discovery compliance certificate. And I will ask you, to the offense alleged in the indictment, state jail felony possession of a controlled substance, do you plead guilty or not guilty?
Guilty.
Right. Has anyone promised you anything other than your plea bargain with the state to get you to plead guilty?
No, Your Honor.
Has anyone harmed or threatened you or anyone close to you for your plea?
No, Your Honor.
Has anyone promised you an early release from your sentence?
No, Your Honor.
All right. I'll find that you made your plea voluntarily and you're not under compulsion in making it, and I'll accept it. And I'll ask what evidence the state has to substantiate the defendant's guilt.
Your Honor, we offer states one and its attachments.
No objection, Your Honor.
All right, without objection, State's Exhibit Number 1 and its attachments are admitted into evidence. Do both sides rest and close at this stage?
Rest and close, Judge.
Rest and close, Your Honor.
All right, let me go and look at the exhibits. All right, I'll find there is enough evidence to substantiate the defendant's guilt. Are both sides ready for sentencing?
State's ready, Your Honor.
Defense is ready, Your Honor.
Okay. Is there a pre-sentence investigation or a waiver of one?
I emailed that to you, Your Honor.
Oh, let me look here. Oh, here it is. Okay. All right, Mr. Villa, if you had a chance to look at the PSI.
Yes, Your Honor.
Any objections or additions to it?
Judge, I don't believe so.
All right, what is the plea bargain in this case?
Your Honor, it's a term of deferred adjudication for 2 years, a fine of $1,000, court cost of $90, Crime Stoppers fee of $50, 160 hours community service at 16 hours per month, drug offender education program, standard drug offender conditions of probation, a drug test fee of $50, education, drug, alcohol evaluation, follow recommendation. 81st 218 Judicial District Substance Abuse Outpatient Program, monthly probation fee of $60, restitution of $99, and a police officer fee of $5.
All right, sir, did you hear what was read in the record by the state's attorney?
Yes, Your Honor.
Is that your plea bargain with the state?
Yes, Your Honor.
All right, did the state's attorney add anything or leave anything out of your agreement?
Yes, no, Your Honor, he did not.
All right, give me just a moment. I'm not finding where there's actually a copy of the plea bargain agreement that made it back in this package. Let me open this up. All right, Mr. Villa, do you still have a copy of whatever was signed up? Because I'm looking at, I just went and grabbed a copy back out of my email from Ms. Sawyer's too, and there's no copy of the actual plea bargain agreed punishment recommendations.
Your Honor, I'm looking at what I submitted yesterday. Please give me a moment.
Go ahead.
I don't see it in, I see it in my hard copy, Judge. I don't see it in what maybe it didn't get scanned, Your Honor. Give me one moment.
Okay, that's fine. Go ahead. I just want to make sure we have this complete. All right. And Mr. Diaz, what sort of work do you do where you says construction in a flooring?
I do a bunch of restroom and kitchen remodels, a bunch of flooring, wood floors, tile floors, laminate, pretty much any floor. Painting. I work for myself. I'm self-employed. Been self-employed for about, under this business name, for about 8 years.
Okay.
Judge, may I can I step away for just one moment to find that?
Yes,
document?
go ahead.
Thank you, Judge.
All right. Okay, I need to go and I'm going to look something up. I'll keep my speaker.
Your Honor, if I may, I think we had a bit of a snafu. I knew we had two different versions of this document. One that my client was handling, and that was the one that got sent over to you. It appears from my looking at these documents that that particular part of the plea packet was not, I don't seem to find it. I'm almost 100% positive we signed. We're doing that. I do not have the, say that again.
If we need to, Your Honor, we can get a copy from the DA's office of the plea agreement and take it over to probation for Mr. Diaz to sign and send a copy to Mr. Villa to sign.
And Judge, I have a copy of the document that needs to be signed. It's the agreed punishment recommendations, Your Honor. I can sign it and send it over for my client's signature. And again, I apologize for this. I do not know how that happened, Your Honor.
Judge is muted.
Judge, you're muted.
Okay, that's something else weird. I did not mute myself. So I guess Miss Poppy muted me. Throw her under the bus.
No, sir, I've been working on an indictment list.
Okay. Yes, Mr. Villa, if you'll get a copy signed up, if you need to see your client in a breakout room, do that. Let me know when you've got that done.
We've already reviewed the document, Judge. I just need to get it over to him. I'm not
That's fine.
quite certain who I need to send it to, Judge.
If you'll just scan it in a PDF and
If
post
someone
it,
from probation would
post it in chat to everyone, probation can grab it and get your client's signature. Or if it already has, I'll grab it.
I'll do that, Judge. I do need to get my client.
Okay.
I went over it and I know we signed. It's,
All right. Mr. Villa, you keep breaking up. Just go ahead and post that document to everyone in chat, please. And we'll try to get probation to go over it to get it to them.
Thank you, Your Honor.
All right, while we're waiting on that, Mr. Diaz, I was asking, do you have any licenses from the state or from the city municipalities up in Bear County?
Negative. When I do flooring work and painting, it's not required for me to have a license at all.
Okay.
I do not have a contractor's license, if that's what you're asking me.
Yes, also asking that. What would you need to do to get a contractor's license?
Just take the contractor's test. I think I go to the courthouse or to Bear County and I take the contractor's license test. I just need to study the book. Pretty much know all the terminology. I don't contract out too much. I just kind of give my friends' names out. We have a circle of contractors. Like, I got a plumber, I got a framer, and a window guy, and I just kind of pass out their numbers when one of my clients asks for that.
Okay.
I do work for a couple different contract builders. I do work for a couple builders in San Antonio. A couple guys that flip houses. I also do work for them as well.
Okay. And do you have any employees that you withhold Social Security and Medicare and federal income tax on?
Yes, yes.
Okay.
Judge, may I approach?
Yes, sir.
Ms. Poppy emailed me that my client had joined the Zoom, so I came back. Mr. Salinas?
Yes.
Okay.
He's
I
the
believe-
gentleman, the man with no eyes, sunglasses.
Yes, sir. That's going to be a trial case, Judge, so I had to ask for that May 3rd date.
Right, just post that in chat and you might discuss with your client that when folks are substantially late as he was, I highlight their name in orange on my docket so I can go back and keep track of whether they've had a problem with appearing in court on time.
Yes, Judge,
Post that, he's excused.
Judge, may I ask Ms. Poppy to put me in a breakout room so I can get a good number for my client?
Yes, sir, I'll do that.
Your Honor, I just got an email from Sean Dawes. He's still tied up at the 186th or wherever he had gone to, and said he may not be able to come back here until right after lunchtime, and ask if you would still have the docket running.
I'm going to be here for a while, it looks like,
Yeah,
yes.
he has 3 pleas.
I think we've got a couple of others without him. And our extradition to Tennessee.
Okay, I will let him know that just to arrive as soon as he can.
Your Honor, when you get a chance, could me and Mark and Lorena, if she wanted to, talk to you in a breakout room?
Is it about the extradition case?
Yes, I just filed a withdrawal on that case.
No. The reason being, based on the representations that Mr. Lockbaum wants to represent himself, and just based on the vibe I get from he and his family, I think it would be better if we could all say with absolute candor that we had not had any off-the-record meetings about this case.
That's fine, Your Honor.
There's a time when that's very appropriate. I think this is probably not one of them. All right, here's Mr. Villa. I got that. Okay.
Your Honor, I have printed it out and given it to Andrew Flores to take over to Mr. Villa to sign.
All right, and whenever we have that from signed by Mr. Diaz, please let me know.
I am emailing it right this minute, Your Honor.
She's like, she says she's crying, and she's like, I'm not raising the hand. So the judge kind of, in his kind, nice voice now, he's all, you've signed it. This is what we're trying to get it into effect because you've signed the summary. Once I've signed this, you have 30 days to ask for a new trial. And then you can
Okay,
ask
I just
for
hit
whatever
send.
you're trying
It went
tell
to
me
you.
today.
Okay. Let me combine these together. Okay, and Mr. Diaz, is this also your signature on page 2 of the agreed punishment recommendations?
Yes, it is.
And did you also understand this document before you signed it?
Yes, Your Honor.
All right. Anything else from either side?
Not from the state, Judge.
Nothing further, Judge.
Okay, all right, then I will follow the plea bargain agreement in this case. I find there's enough evidence to substantiate your guilt, but I will not find you guilty at this time. Instead, I will place you on deferred adjudication probation for a period of 3 years with all the rest of the terms and conditions of your plea bargain agreement with the state. I will add one additional clause that says that if you, and where are the contractor's licenses in Bear County? Bear County, is that city or county or both?
That's county, sir, if I'm not mistaken, Your Honor.
It says that if you get a Bear County and or city of San Antonio contractor's license in the next year, that will take 40 hours off your community service restitution. Community service restitution. Let me finish typing that out.
Thank you, Your Honor. Did
Your
I?
Honor, I'm sorry to interrupt you, but you said 3 years deferred?
That's what I heard.
How much was it? 2?
I thought it was 2 years.
Okay, 2. I was going from memory.
It's okay.
Thank you, Your Honor.
All right, sir. So you understand that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes, Your Honor.
All right. I find that you made your post-trial waivers knowingly, intelligently, and voluntarily also.
Yes, Your Honor.
And I also, and I'll certify to the Court of Appeals that you have waived the right to appeal and you may not appeal because you followed the plea bargain agreement in this case. I also want to remind you, sir, about your community service or restitution hours. You can get the time off if you'll get that license. And also tell you that you live in Bexar County, I take it, up in San Antonio?
Yes, sir. Yes, Your Honor.
All right. You're going to have a probation officer locally here in Wilson County. You will also have one up in Bexar County, I expect that you report to. The Wilson County officer will be the one who makes a decision about whether or not to recommend to the district attorney's office that if they file a motion to have you adjudicated guilty. So you need to make sure that you do everything you're supposed to be doing and understand that because you're up in Bexar County, you're not here locally, your local officer is going to have less ability to check up on you than if they could just go by your house or office and visit you very easily. So you need to take extra care to make sure that they're not getting emails from your Bexar County officer that says you're not following rules.
Yes,
The
sir.
other thing I'll tell you is that if the only thing you're not doing correctly is that you are not paying 100% of the money you owe on time, you will not be adjudicated just for that. You'll be given an opportunity to make larger payments towards the end of the 2 years. And if that's absolutely necessary, we could extend you for some period of time and let you get all this paid off. So if a month rolls around where you can't make a payment, do not fail to go and see your probation officer just because you can't make a payment, okay?
Thank you, Your Honor.
Your Honor, may I please say something? I believe I heard Mr. Diaz do a plea of guilty in the front of the judgment says nolo.
All right, let me change that. Okay, I did not change the name. I just resaved it, posted that.
Okay. Thank you.
Okay, what pleas do we have ready to go?
Alton, he has 2 pleas with Philip.
Okay. All right, we're going to take a 15-minute break. If nothing else, I need to reboot my computer because it's just completely locked up on some of the functions.
Did probation send copies of that PSI to everyone, or do y'all need me to send a copy of that to you? Philip, DAs?
I have not gotten the PSI, but I'm looking. I know Sarah and I have been in contact about it. Let me double check. But no, I have not received the PSI. So if I could get that, that would be awesome. Thank you.
All right, actually, I need to run a quick errand. Let's call it 10 after. I'll be back at 10 after the hour. And hopefully we can go straight through with our pleas and then start on the writ of habeas corpus at 2. So I'm going to leave the meeting now because I need to, as I said, reboot my computer.
Philip, who is that on?
Houghton Christopher.
Okay, let me ask Jean.
Can we please have Christopher Perez at the jail?
Yes, ma'am, let me get him.
Thank you.
Mhm.
Thank you.
Okay, Philip and Lorena, y'all should have an email from me with the PSI.
Send that to me.
I'll let you know when I get it.
Mark,
There it is.
you
Got
do
it.
also?
Send the PSI to me, please.
Okay.
Thank you, Cindy. I can just forward it to him, Cindy.
Lorraine, are you available?
I am. Cindy, what's up?
I was just wondering if we could run through the docket real quick because I had gotten kicked off for a while, so I'm afraid that there are dates I missed.
Sure.
Jennifer, are you available to go over it real quick? I guess not. Okay, Lorena,
Yes, ma'am.
front page.
First page. I have Deidre Silva pled 3 years, TDC.
Mm-hmm.
Albert Aguirre reset to 324.
Okay.
Griselda Vasquez reset to 5-3.
Wow, I didn't have that. I missed a few. 5-3, okay.
John Wesley Albright, one, did he ever show up?
I never saw him, but Guillermo showed up. But I think Jennifer had asked me, she said that Guillermo had posted a date, but I never saw Albright here. And then Guillermo ended up coming back in again.
I saw, he talked to me privately about 5-3, but I never saw a posting, but I didn't see several postings today, so I don't know what's going on.
Okay.
So I had reset to 5-3, but I don't know if Mr. Albright showed up or not.
Yeah, I didn't know on that either.
He did post and it does say 5-3 in the chat.
Okay. Yeah, my chat, I don't have all of it there since I got kicked out.
Suarez is 5-3.
Uh-huh.
Rodriguez is 5-3.
Okay.
James Everett Sellers, that's going to be a plea.
Okay, and I have talked to Sean and he's still stuck in San Antonio. He will report here as soon as he finishes that plea.
Okay. Steven Salinas is reset to 5-3.
Okay.
Jose Rios is a sentencing.
Yes.
Short, quick sentencing, but it'll be a sentencing.
Okay.
Gilbert Salinas is reset to 3-8.
Okay. Is that just a status hearing or what is that one?
That is in order for him to, because he didn't have any technology, any way of getting to court, so we reset it for the week.
Okay, a pre-trial setting. Okay.
Give me just a minute. Let me try and catch up with y'all. Or are you already at the end?
No, we're on page 2.
Gilbert. All right, so he showed up late.
He's going to do a sentencing and
3-8.
Yes, Your Honor.
Thank you. Well, let's see if it'll work. It's letting me type and not even in Greek. Okay. All right, thank you.
So Joe Luke Sanchez was 5-3.
Okay.
Nathan Wheelis was 5-3 as well. The next one, Mr. Gonzalez, I know Mr. Watkins emailed me, but I hadn't had a chance to visit with him. And then I noticed he posted 5-3. Reading his text, it sounds like it may be a contested hearing to competency. So I'll visit with Mr. Watkins. I may need Dr. Wood to come back in and visit with Mr. Gonzalez.
Sanchez 5-3.
Yes, sir.
Sapp, did she ever appear?
I have her as a nice eye.
Hinojosa has new dates. Just her son died.
Yes, 324, Your Honor.
Rose
5-3.
Tellez
5-3 as well.
Torrey has a pretrial diversion.
Yes, sir.
He said on request. Gibson, Nisai.
Nice side, Your Honor.
I don't doubt that's what they told Mr. Briggs, but that DeWitt's awfully far out from San Antonio or Victoria or anywhere else with a federal courthouse for the feds to store him there.
Yes, and our investigator actually checked even just the statewide system, and he's not showing anywhere, as well as the federal system. So I don't know if he's in federal.
Here's Richard, yeah.
They've moved him out of state. I'm not sure.
And I mean, they may keep him in DeWitt. I don't know, but usually they're closer to.
Yeah.
Well, like
so they can transfer them. Yeah.
Right. All right, Jocelyn.
5-3, Your Honor.
Norval Lynn.
5-3.
So Greenwood.
5-3.
All right, so all the rest of the page is 5-3.
Yes, sir.
Okay, Clark.
5-3, Your Honor.
Norval Lynn, 5-3. David Marroquin, did he appear?
I have him as a nice eye.
No, Your Honor, he did sign in. He was there, Lorena. And Jason put him down for 5-3. And I think we have a nice eye on his other case from last week, I think on the 22nd. But it was a case that he did not have an attorney appointment on. It's one that we said we needed to get Jason on. So I don't know if that nice eye, if anybody notified him, we did send a letter out and it did not come back. But he does have a nice eye, Your Honor. I don't know if we need to talk to Jason about contacting DA's office or if we let that stand.
No, he needs to get in touch with the DA's office and see if they can work something out or get him surrendered.
Okay.
And if he's showing up, we probably got to get something worked out. But I'm sorry. McCloskey?
Reset to 5-3.
And do we have a date on Christopher Perez?
Yes, she posted for 3/24.
Is that just going to be a status check or what are we doing there?
She asked in private chat if, because that way he was asking that she get in touch with parole sooner rather than later. So I think she just set it for 3/24.
As a
So
status hearing. Okay. We'll do
yeah.
it.
Rutledge?
3/24.
Ortiz, was that a plea? Or?
He's going to be a plea, Your Honor, on 3/8.
Houghton's supposed to be a plea in a moment?
Yes, sir.
Jones?
He was going to set it for next week. He's the gentleman that just was released from El Paso yesterday. So I don't know if Mr. Lambert's going to do 3/8 or 3/10.
3/8 is what I put on the calendar, Your Honor. But again, I didn't have any contact back and I called the number earlier, so we'll see.
All right. Mathewson?
Reset to 5/3, Your Honor.
Mendoza was a final judgment. Pinshorn 3/8.
Yes, sir.
Rutledge 3/24.
Yes.
Mr. Fraga,
I did not get the reset date. I know Andy was talking to him, but I didn't get the reset
We
date.
put a pretrial to hire date of 3/24.
okay, Diaz, plea. Nancy Davis,
Reset to 5/3.
Ramirez,
Reset to 3/22. Hopefully he's going to plea on that date.
all right. Sellers is supposed to be a plea. Houghton's
Yes, sir.
supposed to be a plea. Spalding's supposed to be a plea.
Yes, sir.
All right, can we go back to a couple of first 2 pages?
Yes, Your Honor.
Okay. Silva was final judgment. Aguirre,
Reset to 3/24.
Vasquez,
Reset to 5/3.
Albright. Nice.
Reset to 5/3, Your Honor.
Oh, okay, he showed up.
Well, we don't know. I never saw him. I know Mr. Laura showed up, but I never saw his client.
He posted to chat about something about them being in the hospital over the weekend, but
Oh, see, I never saw that.
I ought to have a copy of that saved somewhere, but every time I leave, I lose all the chat.
And if his client's been in the hospital, I'm not going to call it. He's been at all our other
Right.
court hearings.
Right, has never missed, so.
Yeah.
Suarez
Reset to 5/3.
and Rodriguez.
5/3.
Sellers is supposed to be a plea. Steven Salinas, he did appear late. What date did he get?
5/3.
5/3, yeah.
And Rios,
Is a sentencing, Your Honor.
And it's ready to
still
go.
coming up.
I think you have the plea packet from our
Okay.
original open plea.
can I confirm the next one with you on Gilbert Salinas? Was that 3/8?
Yes, ma'am, it is.
Okay, and on Houghton, I have the PSI, but I don't have anything else. Was that done a long time ago?
It was, Judge.
I emailed the
The
whole
sentencing,
this morning. You don't have everything there?
so this is just sentencing?
It is just sent on Houghton, Your Honor, it's a plea. On Jose Rios is a sentencing.
Okay, all I have on Houghton is the PSI. So was this plea package done earlier?
It was, Your Honor. He has 2 cases.
Sean Spalding, Sergio, James Williams. Okay, I sent that one at 8:34 this morning, Your Honor. It shows it went through. I can resend.
All right, let me see. Yes, mine skips from Christopher Perez at 8:33 and to Mendoza at 8:42.
Okay, let me resend that. That is strange because it.
Yeah, I searched by Houghton and there's an Ashley Houghton. I've got a bunch of things on her, but this is PSI is all I have on Christopher.
Okay, coming again. Please let me know if you get it.
All right, nothing has come through. Do you want to try and?
Okay, let me just do a brand new email. We'll do a brand new one. Maybe I need to shut down my computer and reset and restart. Did it come to you?
No.
Okay, I'm going to get out and shut down and restart and see what happens.
Search.
Pardon me, Lorena, do you have a minute?
I do.
I just got off the phone with the DeWitt County Jail. They said they do have Daniel Gibson in custody.
Okay, well,
The person who answered, I can give you a phone number.
well, and that's fine, Richard, if they're giving different answers to different people than today.
I understand your feelings on that, but and frankly, if the guy's in custody, federal custody on something, he's probably in bigger trouble than he is here. So,
Sure. Do you know what he's in federal custody for?
no, I don't.
Is he in federal custody in DeWitt or?
He is in custody in DeWitt County.
But for the feds or for?
That's my understanding, yes.
Your Honor, I have a copy of the plea packets that Mr. Lambert and his client have signed. Do you want me to forward those to you?
Please. Hey, Miss Poppy, are you there?
Yes, sir.
All right, I'm going to share the screen and actually, hold on a second. Okay, now I'm going to share the screen. All right. It's a little hard to see because I put it on my second screen, but here's the text share thing I get now, which has horrible numbers on appointment timelines, but I think a lot of that's because we keep having people stuck in limbo. The first queue is the attorney requested queue. This is the queue that we should never have people in here very long, and they will just pop up. They'll pop up with a date a year old or a year and a half old sometimes. I'm not sure what happens. I think people start to enter them in. But whenever you start to enter a new offense in or a new chance to appoint somebody, you go to here. What happens sometimes is all of these, it says add FQ. That's the financial questionnaire, except for the two that say edit financial questionnaire. So on the add, it's never been, financial information's never been put in. On these two that it says edit, it hasn't been finalized, and I've gone in and tried to finalize them, and it said there was an error in saving it. Once you plug them in and we have the federal guidelines in, which they had expired and we hadn't put them back in until into last week, it goes to the determination queue, and I just approved a couple. Let's see if there's any felonies in here. DWI, misdemeanor B. All right, robbery.
Is this what you were showing me to show Judge Ellison? Is that correct? Is that what you're trying to?
Well, yes,
my
it's to
question
show,
was?
and again, he used this before I did. I'll swear, he used it, I thought, in county court at law. Okay, now, do you know, was there somebody appointed, did he have county court, did he have district court in Atascosa today?
He did yesterday.
Okay. All right, well, I'll go to the appointment in just a minute. And this is just kind of, you get the recommendation, which says when you plug their numbers into the federal numbers, what do you come up with? Most of the time, you know, I'll just go with whatever they have. There's been a time or two I've overruled it, and usually it's been somebody that just barely outside the guidelines, and they have, you know, 4 cases and 2 of them are first-degree felonies or something.
So you were having to make them eligible, but when that guideline is put in there before they're entered, that guideline will determine behind the scenes if they're eligible or not. Is that right?
Yes, and the judge can overrule it one way or the other. But I'm only.
So right now it's a manual process just because that wasn't set. Is that right?
No, I put those numbers back in. Apparently, not apparently, that you put the level in that says, here's our level, but it has an expiration date. And once it
Okay.
expires, there's no level at all, which is what we had for a while. Okay. And then we go to the appointment queue. And these are people who need to have attorneys appointed. And like Rose Perez yesterday, we couldn't make this. Okay, let's see if I can do this now. Now, Adrian
And
Perez
then,
was appointed to represent her. But one of the things I found out that, and it has Adrian, okay? And I appointed him yesterday. So why she's back here, I don't know. I'm going to hit save and hopefully it'll go away. And then you should get an emailed notice. He should get an emailed notice that he's been appointed. And we have these other three folks. Do you have any idea if they were in court yesterday, any of these three? And if they were, did they get?
that's what I'm trying to look up.
Okay. And I see I got an email. What did I get?
Yes, Bedwell was in yesterday. You know, I saw that name a second ago.
And one thing I didn't ever know what the problem was, but sometimes I could not override the automatic appointment. And what it is it has to be, whenever you go in and define the offense, you have to not just have the level, but the court. And there's only one option for felonies. Actually, I don't think it segregates them out. I think that you could, you know, as far as they're concerned, you could file capital murder in county court in Wilson County. I think it wouldn't give you an error message, but they had not put down the district court as the court. And if you're not the judge of wherever it's pending, then you're not allowed to change the automatic appointment. So I'll show you how we did this, and then we'll go and work
So
on it.
Judge Ellison was in Frio County yesterday. You were actually over at Escosa, and I would need to ask Lori on her notes because I don't show anyone assigned for Bedwell. So I don't know what your notes from yesterday might say.
Is that person even on the docket?
That's a person on the docket, but it's just the docket notes aren't complete. It just says reset to 3-3.
All right, hold on.
Needs to be interviewed.
Needs attorney, right?
Yeah, now
Okay.
needs attorney. I'm just reading all her notes because that was not there.
Okay, so needs attorney and cancel. No, okay, and now it appoints Adrian Perez. Okay, Francis Cantu. I think she was one of the add-ons. And I think all three of these, the answer was that, let me find the add-ons. The answer, I think, on all three of these was that, well, Perez, okay, and Renner, see the other one? Okay, Victor Hernandez, that they did not get into the system. Yeah, Victor Hernandez. They did not
Yeah,
get.
they're set for 3-3. They just sent them the 3-1 notice. I checked that yesterday.
Right. And another problem we keep having is they enter the, I say they, I'm not saying it's rural legal aid because the JPs can enter stuff too, but offenses get entered multiple times and defendants get entered multiple times, and then their offenses get entered multiple times. And that's one of the ways that we wind up with multiple appointments. All right, so I'm not going to appoint on any of these three. I'll wait until we're there tomorrow, and one or two will go to rural legal aid, and the other one or two, we'll see who's present in court. Okay.
Okay.
All right, so. Okay, and let me ask on Mr. Houghton. Who did the fancy thing here? That, is it Mr. Houghton himself? Was it Mr. Lambert who generated these so that it has signature panel up at the top?
Your Honor, whenever I use the Adobe eSign software, which I usually try to take it back and then I have to take off all of the software stuff, but I'm unsure of which one you got, but the one I send, I have to file with the court. I have to rescan it in, so it should be pretty simple. Is it giving you like a glowing prompt to sign? Because that would be the original Adobe.
Well, no, but my issue is that whenever I've tried to sign things here before, it has not let me. Yeah, see, it says the author of this form has specified the fields which you can fill.
I know what it is. I have to send you, so the Adobe security stuff prevents it from.
Right.
Let me, I have a saved copy that has all that stuff taken off. So give me 1 second.
That's okay. I'll just print it to a PDF.
Okay.
That's close enough.
Your Honor, did it not come through again? I resent.
No, it came through. It's just that it came through in a format that I can't sign it. But I will print it to a PDF.
Oh, it shows it was in a PDF, is how it was.
It is. It's in a locked PDF that no one can sign.
Okay.
Are y'all gonna do his plea next so I can pull him into probation?
I hope so. And Mr. Lambert, if you can figure out a way that you can send it over, because I have, I mean, I have a registered thing with Adobe. I have it set up where my signature is verified. If you could figure out a way to send it over where I can sign it and all of our signatures are verified, that'd be great. But
I don't know why it does that. We've had a serious problem with that and have tried to look up multiple things. The only way we figured it out is I have to get it signed, print it out, and rescan it without the securities. I sent you and Lorena a copy of the documents to your email and to her email as well, just to verify.
okay. Well, you ought to be able to just print it to a PDF.
The security's on, right? We've tried it. I have no clue. I've looked up online, or have yet to beat the system yet.
Okay, I'm able to do that, but I understand it may be doing different things on different computers. Or I don't know if you have, okay, so is Mr. Houghton in?
Yes, sir.
Okay, and the judgments?
You get a copy of them, Your Honor?
I'm looking. No, I just have the plea package.
Oh, yeah, I don't have the judgments. I only have those.
I can send the judgments to you, Your Honor.
Okay.
I just sent those judgments to you, Your Honor.
Thank you. All right, calling State versus Christopher Charles Houghton. Are both sides ready?
State's ready, Judge.
Defense is ready, Your Honor.
All right. Are you Christopher Charles Houghton?
Yes, sir.
Is that your true and correct name?
Yes, sir.
Mr. Houghton, can you speak, read, and write the English language?
Yes, sir.
Okay, and are you a United States citizen?
Yes, sir.
Despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes, sir.
All right. Do you have any history of mental health problems or mental illness?
No, sir.
Counsel, do you believe your client's competent to stand trial?
I do, Your Honor.
Okay. All right, sir, you are charged in two different cases. In cause number 20-05070, which I'll call the weapon case, you are charged with by indictment with the third-degree felony offense of possession of a prohibited weapon. Specifically, it's alleged that on or about January the 5th, 2020, here in Wilson County, that you did then and there intentionally or knowingly possess a short-barreled firearm, which is a prohibited weapon. That alleges a third-degree felony, which is punishable by confinement for not less than 2 and not more than 10 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is in the weapon case?
Yes, sir, I do.
Okay. In cause number 20-11-302, you are charged by indictment with the state jail felony offense of unauthorized use of a motor vehicle. Specifically here, it's alleged that on or about July the 2nd, 2020, you intentionally or knowingly operated a motor vehicle, to wit, a motor propelled vehicle, to wit, a truck, without the effective consent of Garrett Sena, the owner thereof. That alleges a state jail felony, which is punishable by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. So do you understand in that case what you're charged with and what the range of punishment is?
Yes, sir.
You understand that the plea bargain agreement you have with the state is not binding on me. I do not have to follow it, but if I were to decide not to follow it, I would allow you to withdraw your plea.
Yes, sir.
Okay. If I do follow the plea bargain agreement that you have with the state and the sentence I impose is not harder on you than what you have agreed to, then you will not be able to appeal this matter. Do you understand that?
Yes, sir.
Okay. Finally, if your plea bargain is for deferred adjudication probation and I should decide to follow it, I would find there was enough evidence to say you're guilty, but I would not do so. Instead, I would defer or put off a finding of guilt and place you on deferred adjudication probation. And if you successfully complete that, the case against you will be dismissed and you may be able to get an order of non-disclosure to keep the state from telling anyone other than law enforcement that you were even arrested. On the other hand, if while you're on deferred adjudication probation, the state alleges that you have violated the rules, then you could be arrested, you could be brought back to court, and there would be a hearing on just that question. Did you violate the rules? And if the answer to that turns out to be yes, then you could be found guilty and you could be sentenced to anything that's a legal sentence. Underlying cases. In the weapon case, that would be 2 to 10 years in prison and a fine up to $10,000. And in the other case, the vehicle case, that would be 180 days to 2 years confinement and a fine up to $10,000. Do you understand that?
Yes, sir, I do.
All right, I want to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Plea to the Court. And beginning with the weapon case, let me ask you on paragraph 2.11, is this your signature?
Yes, sir.
I'm sorry?
Yes, sir.
And on the unauthorized use case?
Yes, sir.
And did you also, and do you swear or affirm in both of these cases that, actually, I'm sorry, on the verification on first the weapons case, is that your signature where it says verification?
Yes, sir.
And also on the unauthorized use case?
Yes, sir.
And on both of these, do you swear or affirm that everything above your signature is on where it says verification is true and correct?
Yes, sir.
Did you also sign the certification of right of appeal in the first case
Yes, sir.
and the second case?
Yes, sir.
And agreed punishment in the first case?
Yes, sir.
Actually, the second case? In the first case?
Yes, sir.
Waiver of preservation of evidence in the first case?
Yes, sir.
Second case?
Yes, sir.
Discovery compliance certificate in the second case?
Yes, sir.
In the first case?
Yes, sir.
All right. Did you read all of these documents yourself, or did your attorney, Mr. Lambert, read them to you?
I read them.
Okay. Did you understand these documents before you signed them?
Yes, sir.
Are you satisfied with the work that Mr. Lambert has done for you in these two cases?
Yes, sir.
All right, counsel, do you believe in both cases that you've received all of the evidence, pardon me, the discovery you're entitled to in a timely manner?
I have, Your Honor.
And do you believe in both cases that your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
I do, Your Honor.
Okay, I will accept the discovery compliance certificates in both cases, and in both cases, I will find that you made your waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I'll ask you, in the weapons case, the third-degree felony offense of unauthorized, possession of a prohibited weapon, do you plead guilty or not guilty?
Guilty.
Okay. And in the second case, the state jail felony offense of unauthorized use of a motor vehicle, do you plead guilty or not guilty?
Guilty.
All right. And in both of these cases, has anyone promised you anything other than your plea bargain with the state to get you to plead guilty?
No, sir.
Has anyone harmed or threatened you or anyone close to you to get you to enter these pleas?
No, sir.
All right. Has anyone promised you an early release from your sentence?
No, sir.
All right. I will find in both cases that you made your pleas voluntarily and you're not in any compulsion in making your pleas, and I will accept them. And I'll ask what evidence the state has.
Your Honor, we offer states one and its attachment in each case respectively.
We have received those, Your Honor. No objections.
All right. Without objection, State's Exhibit 1 and its attachments are admitted into evidence in both cases. Do both sides rest and close at guilt innocence?
Rest and close, Your Honor.
Rest and close, Your Honor.
All right. Give me a chance to look at the reports. All right. And has anyone put a tape measure to that short barreled shotgun? It looks less than 18 inches to me, but it's hard to tell from a picture.
From the pictures, Your Honor, it looked like it.
All right.
I think in the bottom of the report, Judge, which is included, from the cutoff stock to the end of the short barrel, it was 24.5 inches in length. Second to last paragraph, second to last sentence. And Officer Pena's report.
They have it at 24.5 for the stock on. Is that the picture you're talking about on page 14 of the discovery packet?
Right. Give me just a moment. Okay, I did not recollect that there was an overall length requirement on shotguns. I just remember the 18 inches on the barrel length. So I'll find there's enough evidence to substantiate his guilt in the weapons case and look at the other report. I find there's enough evidence to substantiate his guilt in the second case also. Are both sides ready for sentencing?
State's ready, Judge.
Defense is ready, Your Honor.
Okay, I've been given a pre-sentence investigation report. Has the defense had a chance to look at it?
I have, Your Honor, and no objections. I did review it and see that they had the same recommendations as the state.
Okay. All right, so what is the plea bargain in this case?
Your Honor, in the unauthorized use of a motor vehicle case, it's going to be 5 years deferred adjudication with a fine of $1,500, court costs of $290, Crime Stoppers fee of $50, 200 hours community service at 16 hours per month, theft class, $50 drug test fee, education, drug, alcohol evaluation, follow all recommendations, monthly probation fee of $60, police officer fee of $5. The prohibited weapon case, also 5 years deferred adjudication, Crime Stoppers fee of $50, 200 hours community service at 16 hours per month, drug offender education program, standard drug offender conditions, education, drug and alcohol evaluation, court cost $290, police officer fee of $5.
And it's my understanding that the fees are running concurrent, court costs are separate, and community services running concurrent. Is that correct, Mr. Ledet?
That's correct.
Okay. All right, Mr. Houghton, did you hear what was read in the record by the state's attorney?
Yes, sir.
Is that your agreement with the state?
Yes, sir.
Did the state's attorney add anything or leave anything out?
No, sir.
What sort of work do you do when you're employed?
Carpenter, we remodel homes, my family business.
All right. And where do you work at?
We work all over San Antonio. We buy and flip our own houses. My grandfather.
Okay. And, all right. Well, there may be a lot of damaged houses on the market. I don't know, with all the water problems. Are you going to be able to go back to that work and make the payments you need to make, you believe?
Yes, sir. We were just waiting on some permits from a few of the inspectors, and that should be here like next couple of days.
Okay. All right, anything else from anyone?
Not from state, Your Honor.
Nothing from the defense, Your Honor.
All
Your
right.
Honor, I had a question
Yes, ma'am.
too. I'm sorry. I just wanted to confirm if you were gonna grant the motion to withdraw. I didn't know if I needed to be prepared for the hearing or not.
I just want to have an opportunity to speak with Mr. Lockbaum on the record and tell him that I think he's making a mistake. But yes, if that's what he wants to do, it's not a criminal case. It's that weird quasi criminal thing. But yes, he will be allowed, unless he changes his mind, he'll be allowed to represent himself.
And then I was also wondering, with.
All right, Ms. Starling, let me finish this, please.
Oh, I'm sorry. I thought you were done.
No. Okay, so I'll find in both cases, there's enough evidence to say you're guilty. I will not do so. I will place you on deferred adjudication on both cases with the times and conditions that you have agreed to with the state. I will amend the waiver of preservation of evidence in the weapon case to make it clear that the short 28 and 20 gauge is being forfeited. I think that's contraband and it couldn't be returned to you anyway, but just so that the PD doesn't have to come back and get some other piece of paper to authorize them to do something with it. And I see that you live up in San Antonio, sir, so I want to talk to you about a couple of things. Remember what I said about deferred adjudication? If you do everything you're supposed to do, then the case against you will be dismissed. If you don't, then, or if the state alleges that the case against you will be dismissed, you may be able to get an order of non-disclosure. If the state alleges that you're not doing what you're supposed to be doing, then you could be brought back to court under arrest, and there would be a hearing on just that question. Did you break the rules? And if the answer turns out to be yes, then you could be found guilty in both cases and sentenced to anything that is a legal sentence for that particular case, 2 to 10 years or 180 days to 2 years confinement, and a fine up to $10,000 in each case.
Yes, sir.
I expect that you're going to have a probation officer up in Bexar County and make sure that you're doing everything you're supposed to be doing. But if the day comes around and you can't make a payment, don't fail to report to your probation officer simply because you don't want to go and tell them that you don't have the money. Make sure that you're reporting, doing your community service hours and everything else. All right. So you understand that because I have followed the plea bargain agreement that you have waived the right to appeal and you may not appeal?
Yes, Your Honor.
All right, so let me get all these signed up and I will get them posted to the clerk and then we'll start the next case.
Thank you, Your Honor. And Mr. Hobson, I think they need your fingerprint, but other than that, can he be dismissed, Your Honor?
Yes, sir.
Thank you, sir.
Well, I mean, released to probation. They may want
Yes.
the report. I'm not certain.
And
Yes, sir.
Mr. Houghton, call me when you get out and we can chat, okay?
Yes, sir. Thank you, guys.
Thank you, Your Honor. That's all I have. Can I be dismissed as well?
Yes, sir.
Thank you, Your Honor. Have a great one.
Afternoon. Is Miss Whitney possibly available for a breakout room with me?
Judge, I'll need that ability again. I don't have it currently.
Okay, you're the host.
Ms. Sterling, were you still needing to speak with the DA?
Jennifer, were you talking to me?
Yes, do you still need to meet with Martha Lorena?
Yeah, I was just wondering which one was on the the Christopher Pettis case.
That's me.
Oh yeah, could I just talk to Mark in a breakout room real quick? I just want to make sure I understand what I walked into.
Yes, I'll do that now.
Okay, and he pled guilty, I think.
Both DAs are tied up at the moment, sir.
All right. All right, I just posted both plea packages and both judgments on Houghton to Ms. Sawyer's. Okay, so what do we have next?
I'm downloading them right now. Thank you.
Your Honor, I believe we're ready for the sentencing on Jose Rios.
Okay, and did somebody tell me that y'all had worked that out or not?
We have not, Your Honor.
Okay.
The court, no, I have one witness that should take between 10 and 15 minutes at the most. And I believe Mr. Moreno made 3 witnesses.
That is correct, Your Honor. Depending on the availability of one witness, I'm looking at maybe 2 or 3.
Okay, let me. Download the PSI again. Okay, was there a PSI in Rios?
There
Yes,
was
sir.
one done. Yes, sir.
Oh, I got it. I received it on the 22nd. Okay, I thought I'd seen one. All right, has the defense had a chance to look at it?
I have, Your Honor.
Any objections or additions?
One addition, I mean, I guess a couple of additions, Your Honor. I don't know if it was discussed with the probation officer when he went in and discussed with them, but Mr. Rios has also completed a couple of courses, a DWI program, as well as a victim impact panel, and has been attending AA. And I have certificates for the courses to provide to the court, but I have no proof of the AA due to everything being on Zoom.
Mr. Marino, I have no objections, but we probably need your client.
Oh, yeah, I was just notifying the court that that would be in addition to the PSI.
Okay, all right, and where is he?
He is at probation, Your Honor.
Okay, if we could get him to the defendant computer?
He's actually in the front lobby, Your Honor. Hold on.
Yeah, I haven't looked at that. I signed all those other things that were sticking here. And there's a criminal case here. Is that what you're looking for?
No, it's this one here that I was looking for.
Okay.
Citation by posting a publication that they're calling on.
Okay, I'll look at that. All right, tell me when we have him available.
He's on his way from our lobby over to probation. He should be getting in there in just a second. Is there somebody from probation that can meet him at the back door?
I believe Andrew has stepped out to get him, Cindy.
Jennifer, I have a notice for breakout room 10. Am I supposed to go in there? This is Mark.
Did you go on with Kathy earlier?
I've already done that. Yes, ma'am.
Okay, so that's what that's from. I'm not sure why it's popping up again.
All right. Thank you.
Your Honor, we're trying to get the breakout room in the front of the courtroom for any witnesses for Mr. Rios's case.
All right, thank you. All right, is that Mr. Rios?
It is, Your Honor.
All right, so we're ready to start?
State's ready to proceed, Your Honor.
Defense is prepared, Your Honor.
All right, go ahead, Ms. Whitney.
Thank you, Your Honor. I call Andrew Flores, Your Honor.
All right, Mr. Flores, would you raise your right hand? You solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth. So help you God?
I do.
All right. And your name?
Andrew Flores.
Give me just a moment. I need to get a different pen. Go ahead, ma'am.
Thank you, Your Honor. Mr. Flores, what is your current occupation?
I'm the unit manager for the 81st to 18th Judicial District CSCD in Wilson County.
And are you familiar with the defendant by the name of Jose Luis Rios?
Yes, I prepared the pre-sentence investigation on Mr. Rios.
And what is a pre-sentence investigation?
It's basically a background and current information for sentencing purposes.
All right. And do you have a copy of that pre-sentence investigation with you today?
I do.
I just want to go through a couple of things in that pre-sentence investigation. I want to start with, do you take, as part of the pre-sentence investigation, do you look at Mr. Rios's criminal history?
Yes.
And I want to talk about that for a little bit. How many prior DWI convictions does he have?
He has 4 prior DWIs.
So this would be his 5th DWI, correct?
Correct.
And 2 of the prior DWI convictions were in county court, correct?
Yes.
And those were back from in 2000, correct? Those were those convictions from 2000?
Yes.
And then he also has 2 DWIs that were heard in district court, correct?
Yes, but the last DWI, I believe it was reduced to a misdemeanor.
Okay. Well, let's start with the Del Rio case. And that was in district court, correct?
Yes.
And he pled in 2005. And what was the sentence back in 2005?
2005, I don't show.
Was he placed on straight probation in 2005 by that district court?
I think that's 2003 you're talking. Oh, I'm
Okay.
sorry. Yes, he was, it was 4 years probation. I'm
4
sorry.
years straight. No, that's okay. 4 years straight probation.
Yes.
And the other district court case that is out of Hidalgo County, did they reduce that down to a misdemeanor?
Yes, that was reduced to a Class A, April 23rd of 2003.
Okay. And he also has he has a misdemeanor conviction for deadly conduct as well back in 2000, correct?
That's correct.
Okay. Now, when Mr. Rios was arrested on this offense here in Wilson County, was he placed on probation conditions?
He was placed on standard DWI bond conditions.
And is one of those bond conditions that he have an interlock?
That's correct.
And what is the other, and one of the other conditions that he refrained from consumption of any alcohol?
That's correct.
And has he been compliant while he's been on those bond conditions?
He has not. I believe he did not get his device installed till, no, he did get it installed within the time frame. He had several BAC violations that were reported to the court. There are several rules too, if there are violations, to contact your officer. And during the course of the pre-sentence investigation, he admitted that he continues to consume alcohol.
Well, let's go back and talk about those BAC violations. Those would be, you're referring to those in regards to the interlock device, correct?
That's correct.
And what is the purpose of the interlock device?
The interlock does not allow a vehicle to start if there's any alcohol detected on his breath.
And you said was it just one BAC violation or were there multiple violations?
There were 4 different dates, I believe.
And as a result of those violations, was there a bond revocation filed and signed by the court?
Yes.
And was Mr. Rios arrested for that bond violation?
He was.
And he bonded out again, correct?
Yes.
And after he bonded out again, did he have any other violations after he bonded out?
Yes, he bonded out in November of 2020. I'm sorry, no, there were, when it was filed in June of 2020. There were interlock violations in the October 18th and 23. However, we did not receive them till after he was arrested on the MTR. They're usually a month behind.
All right, so let's talk about that very quickly. The first violations occurred in June of 2020, correct?
That's correct.
And the other violations occurred in October of 2020, correct?
Yes.
And he bonded out. You do not know of any other violations in regards to the interlock device, correct?
No.
Yeah, you said that he admitted to you during the PSI that he continues to consume alcohol?
It's standard. I go through a substance inventory asking any drug or alcohol use. And he had indicated prior to the interview, his last use was January 30th of 2021.
Which also would be a violation of his bond conditions, correct?
Correct.
Now, does Mr. Rios, he works, correct?
Yes.
And does he work locally or where does he work? And if you don't know, that's fine.
I know he is employed with Patterson Drilling. I believe it's out of town. He doesn't work here locally.
Okay. And Mr. Flores, I noticed on the last page of your or not the last page, but on page 11, you have a proposed supervision plan. Are y'all making any recommendations in regards to sentencing?
We don't make a recommendation in regards to sentencing. However, every PSI includes a supervision plan should the court place the defendant on probation. And with that plan, we did indicate inpatient treatment through CCF.
Thank you very much, Mr. Flores. I pass the witness.
Go ahead, sir.
Thank you, Your Honor. Afternoon, Mr. Flores, you indicated that there was 4 prior DWI convictions in Mr. Rios' past. Is that, did I hear that correctly?
Yes.
What was the year of his latest conviction?
The last conviction?
Yes, sir.
The last conviction, well, the offense date was 2002. He did not come, his last probation expired in 2009, it looks like.
So he pled in 2002?
The offense was in 2002. His last DWI arrest was in 2002.
Okay. Do you have any indication on if he was revoked or unsatisfactorily discharged on any of those probations?
No, I believe they were all completed.
Okay. So between his last conviction, completion of probation, and today's date, it's been over 10 years, correct?
Correct.
And you indicated that he said that he had continued to drink alcohol and that his last use was sometime around January 2021. Did he indicate if that was like how much he had to drink?
So when I did the inventory, he didn't specify. When I brought to his attention that he shouldn't be drinking per bond conditions, he indicated it was just, I believe he said it was wine with dinner.
Okay. And with your supervision plan, should Mr. Rios be placed on probation, you believe that a 6-month to 24-month inpatient treatment at a community corrections facility is the most appropriate action if that were to occur?
I do.
I have no further questions, Your Honor.
I have nothing further for this witness, Your Honor.
Mr. Flores, you are excused.
State rest, Your Honor.
All right, Mr. Moreno?
Your Honor, the defense would call, well, I'm actually honestly, Your Honor, not sure who is present with him. I haven't had a chance to speak with him.
Right.
But
you want to have Miss Poppy put you in a breakout room? You can talk with him.
Just for a moment, Your Honor, just so I can get confirmation on who is present for him to testify on his behalf.
And we do have somebody, a witness here that's in our Zoom room waiting to come in when y'all are ready for them.
Do you have the name for her?
Thank you, ma'am.
I do not have the name. Do y'all have the name?
Okay, y'all go ahead and work on that. I need to call the coordinator's office for a moment. I'm going to mute my computer.
Yes, Your Honor.
Okay, Mario, it is his wife, supposedly.
Okay. Was she the only one present for him?
Yes, I
I'm
believe
on
that
as
was the
well.
only-
Okay.
The defendant is in a breakout room for you in room 11.
Oh, okay. Thank you.
Excuse me.
Oh, he just came back.
I'm here also for him. I'm his sister.
Oh. Okay.
Do you
Okay.
still need a breakout room? Because the defendant did come back.
Yes, very briefly.
Okay, so I'm going to put you and the defendant in a breakout room again.
Thank you. Is it still room 11?
I'm putting you on 12.
All right, thank you.
And Jennifer, I guess you can go ahead and pull that other witness in, since we have one witness that's sitting in here. I guess the other one can come in as well.
What do you mean by that, Cindy?
Do you show somebody trying to get in to the meeting? Or you
No.
have there, WC District Court, she's there.
Yes, she's
Okay.
there.
Okay.
And the sister's there.
Okay, thank you.
I returned with Mr. Rio, so we should be good to go as soon as the court is ready.
Okay, I'm sorry, I'm back. Do you have your witnesses lined up, Mr. Moreno?
I do, Your Honor. Can you hear me?
Okay,
Hello?
I'm sorry, go ahead. I had muted my computer as well as my speaker, as well as my mic. Go ahead.
I do have my witnesses ready, Your Honor. Is the court ready to move forward?
Yes.
At this time, I will call Alejandra Medina.
Okay. And where is that person?
I believe she was on, she's
I
there
see.
waving at the court right now.
All right, Ms. Medina, will you raise your right hand? Do you solemnly swear or affirm the testimony you may give and the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Go ahead, sir.
Thank you, Your Honor. Good afternoon, Ms. Medina. How are you doing?
Fine, thank you.
Can you explain to the court what your relationship is with Mr. Rios, Jose Rios?
I'm his sister.
Okay. How would you describe Mr. Rios's character?
He's hardworking. He's liable to take his shirt off and give it to someone that needs it. He's always looking to be helpful. He works nonstop all the time. He goes to work 14 days, comes home and continues to work at home doing side jobs just to make sure that he's providing for his family and, you know, for anyone that he can help. I mean, he goes out of his way for friends, family. His character, honestly, in that regard is flawless.
Thank you, ma'am. Are you familiar with the problems that he's facing in terms of alcohol use?
Yes.
Are you familiar with the what he's charged with? And
yes.
Actually what he's been convicted of?
Yes.
Are you familiar with his criminal history as well, with his previous
Yes.
DWIs? Okay. Do you believe that he is capable of taking the right steps to address his alcohol use?
I do believe so. If I may, you know, speak to that. I understand that, you know, we acknowledge that, you know, what he's convicted of or facing charges for right now is severe, and completely understand that. However, like I said, I mean, he is a very hardworking person. It's not, all I ask is that he's not judged on this action and what it's caused and what he's going through. He and I are, I guess you can say, the backbone of our family. And we help, both our parents have health issues, and we help, you know, with that. He is my backup, I'm his backup. And I just ask that, you know, the judge have that in mind when he makes the decision. I understand, once again, that what he did, you know, is wrong. But I feel that him being able to, you know, work and continue to do what he does, pay his fines, you know, do whatever needs to happen, is what would be best.
So do I hear correctly that should he go to prison, there's a chance that there would be a ripple effect that would have an impact on you, on your family?
It would.
I'll pass the witness room.
Go ahead, Ms. Whitney.
Thank you, Your Honor. Ms. Medina, obviously you love your brother, right? No question about that, correct? Is that a yes?
Yes, I'm sorry.
Sorry, the court reporter. I know we talk with head nods, but with court reporter, unfortunately can't get that.
I understand.
And you would agree with me, your brother, it's not just 1 or 2 convictions. He's now been convicted 5 times of driving while intoxicated.
I understand that, ma'am. It's been between, I mean, he was young when he first had those first convictions. It's been, well over 15, 16 years at this point, if I'm not mistaken. And that's kind of, once again, I like I said just a minute ago, I understand that, it's not excusable and that it's wrong. And he acknowledges that as well. It's just that he's not someone that's always drinking. It's something that happened, and unfortunately, we're dealing with this now.
And you understand he was placed on bond conditions, which
Yes.
would be like being placed on probation conditions when he was arrested and he bonded out. You understand that, correct?
I do.
And you understand he hasn't followed those bond conditions.
What
He's
I
drinking.
understand, ma'am, based on the violations of I don't know what y'all called it, the device that's on his vehicle. There was several things that did set it off that weren't necessarily alcohol. And I'm not trying to make excuses, but these are conversations that we did have when it happened. I wasn't there. I can't, obviously say this happened or that happened. I just based on conversation. But also him saying that he drank while he was having dinner, if he had a drink, I don't know that he read through each document when he signed the probation. And that's not, I guess a social drink isn't necessarily considered binge drinking.
Well, and Miss Medina, you understand, I'm not talking about binge drinking. I'm talking about the fact that your brother did not follow his bond conditions. One, which is that he abstained from any and all alcohol.
Okay.
You understand that? He admitted to.
I do.
Thank you. I pass the witness.
I have no further questions for Ms. Medina, Your Honor.
Okay, your next witness?
My next witness would be Brandy Rios. I believe she was in a breakout room. If
All right, Ms. Rios,
if I
would
heard
you
Ms. Sawyer's correct.
raise your hand, please? Your right hand. Do you swear or affirm the testimony you may give? The matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, go ahead, Mr. Moreno.
Good afternoon, Ms. Rios. How are you?
Good, sir.
I'm going to ask you the same. What is your relationship with Mr. Jose Rios?
He's my husband. We've been together for 20 years.
Was that 20 or 21? You kind of cut off.
Well, it'll be 21 in August.
Now, obviously, well, do you care a lot about your husband, Ms. Rios?
Yes, sir, I do.
That aside, you want to make sure that do you want to make sure that he does what is best for him?
Yes, sir.
And I mean that both physically and mentally and in his life.
Oh, yes, sir.
How would you describe your husband's character as his wife?
He's very loving. He's a very, very hard worker. Like his sister said, he goes to work for 14 days. He comes home and he works for his 14 days off. He's always provided for all of his family, for his mom, his dad. He's got 4 kids, 3 of which are ours together. He has a daughter, which is currently in college, and he's helping her through college. Our oldest is 19 and he's going to college, and we have 2 children at home, which he takes care of all 4 of his children and myself and the rest of his family very well.
And what do you do for a living, Ms. Rios, if you don't?
I'm a licensed vocational nurse.
And are you familiar with your husband's alcohol use?
Yes, sir.
Were you familiar with his criminal history prior to today?
Yes, sir.
And you're familiar with what he's been convicted of and what the charges that he's facing today?
Yes, sir.
Do you believe that he would abide by any orders for treatments and any other probation options if he's given those orders by the court?
Definitely, yes.
Do you believe that he could benefit from a chance to receive treatment to address his alcohol use?
He would benefit from treatment, but in all honesty, I don't believe he needs treatment. He knows what he's done wrong. He's made many steps to correct it.
How would you describe the impact on your family should your husband be sentenced to prison?
It would be a very huge impact. He provides for all of our children. And my daughter, which is only 5, is very attached to him. His mom, his dad, it would cause a huge ripple effect if he were to go to prison or be away from the family.
Is there anything specifically about Mr. Rios, your husband, that you would like for the court to know in regards to sentencing today?
I just ask for some leniency, for something that where he can remain at home, remain working, and continue providing for his family, especially the kids, because the kids are trying to succeed. His daughter's 25 and he's still helping her. He wants her to succeed. Like I said, my oldest son is going to college. He wants to become a nurse as well. And our 2 kids at home, they need him. I need him. And I'm just really asking for some leniency, possibly just probation where he could stay home, continue to work.
Thank you, Ms. Rios. I'll pass the witness, Your Honor.
I have no questions for this witness, Your Honor.
All right, Mr. Moreno?
I have no further questions for Ms. Rios, Your Honor. Next, I would like to call Jose Rios.
All right. Mr. Rios, would you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
And is there anyone else with you in that office?
No, Your Honor.
Okay, you can put your hand down and please remove your mask. Go ahead, Mr. Moreno.
Thank you, Your Honor. Mr. Rios, do you recall going to meet with Probation Officer Flores for your pre-sentence investigation?
Yes, sir.
Do you recall admitting to him that you had been drinking alcohol during the pendency of your case?
Yes, sir.
Can you describe how much alcohol that you had consumed?
That day it was a sip. I took a sip because we had gone to the zoo and it was hot, and we stopped at a restaurant to eat on our way out. And we had some friends that we were meeting there. They already had a beer, and I took a sip. That's what it was.
Were you aware, at least, of your conditions that you were not to consume alcohol while your case was pending?
No, that's one thing I told him. I said I wasn't aware, and he said I was supposed to be calling in a probation officer, and I was never assigned anybody. But I mean, I take full responsibility for doing it.
Yes, sir. What do you do for a living, Mr. Rios?
I work in the oil field right now. I'm a driller. I've drilled probably about 10 years, and I was a rig manager, and then I was a drilling consultant. Currently, I'm drilling for Patterson Drilling. And whenever I'm home, I do construction.
The day that you were arrested on this charge, do you remember what time of day that you were arrested?
About 11 in the morning?
So 11 a.m.?
Yes. It's close to it.
When was your, when did you last consume alcohol prior to your arrest?
It was early in the morning. It was probably say about 2 in the morning, somewhere around there.
What were you doing between the hours of 2 in the morning and the time that you were arrested?
Well, I drank some shots and stuff with some friends, and then I went to sleep. I woke up at 6 and I started driving. I took a shower. I thought I'd slept it off, and I started driving. I drove from Del Rio, and then I stopped at a red light, and it was a long red light, and it just like dozed off.
Did you believe that you were okay to drive?
Yes, sir.
Do you know now that you weren't of the right state of mind to drive?
Yes, sir.
Mr. Rios, since picking up this charge and why your case is pending, have you completed any courses to address the DWI charge?
Yes, sir. I did a DWI education class, and then I did a math class that I drove all the way to San Angelo to do, and then I did another one online. And then I've been
Well, let me
going
stop
to
you there.
AE.
Did you do two, you call them MAD classes? Is that what you said?
Yes, sir.
One online and one in person?
Yep, well, because the one that I went to do in person, I was supposed to receive a certificate, and I never received it. So then I went ahead and did another one online and submitted for the certificate, and I received it.
And Your Honor, I submitted some certificates to the clerks in hopes that I could present that to the court today. Is that available? I don't have screen sharing capabilities on my end.
Don't have them. I don't believe. Do I have those? Who did you submit them
Your Honor,
to?
I can say I have seen those documents. I have no objections to them. If Mr. Marino would just like to email them to you.
I do not have a copy of those in his file, so I'm not sure where it might be.
Ms. Sawyers, I sent them to your email early this morning, like, well, about around 9, maybe.
Okay, let me go into this morning's email.
While they're working on that, Mr. Rios, did you do anything else to address your alcohol use while your case has been pending?
Yes, on my days off, I would also attend DWI classes, meetings.
DWI meetings, or do you mean AA meetings, or are there specific meetings to address DWI?
AA meetings is what I meant.
How often would you go?
On my 14 days off, I do at least 5.
How frequently would you go?
I would try to go every other day, or if I didn't have a construction job set up, I'd go 2 or 3 times. Sometimes I go more in those 14 days.
You should have received those, Your Honor.
Yes, I have. And Ms. Whitney, did you receive these too, or you seen them previously, you said?
I have seen them. I've received them this morning, Your Honor. I've had a chance to look at them. I have no objections to them, Your Honor.
So were you offering these, Mr. Moreno?
I'm sorry, say that again, Your Honor.
Were you offering these?
Yes, Your Honor. At this time, I'd like to offer those as state defense exhibits A and B.
And the state has no objections to them, Your Honor.
Without objection, defendants A and B are admitted into evidence.
Thank you, Your Honor. Mr. Rios, after reviewing, after knowing what it is that you've been convicted of today in this case, and knowing what your criminal history is, are you aware of the potential of there being an alcohol dependency issue with you?
Yes, sir.
Do you believe personally that you would benefit from the chance to obtain treatment to address that alcohol use?
Yes, sir.
Do you believe that if given the opportunity to be placed on probation, you would be able to complete it successfully?
Oh, yes, sir. Yeah.
Do you believe that you would be able to abide by any treatment options or conditions of probation as well?
Yes, sir, I would.
Had you had any issues with being on probation previously?
No, sir. No, I've always completed everything I've been asked to do. And I was doing, I did good for so long, that stayed out of trouble and stuff like that. I'm just trying to be there for my family.
If you can put a number on, like a percentage, how much do you believe that your family depends on you, on your income and your support and things like that?
I said 90-95%. I help, like my sister and my wife said, I help my oldest kids, in school. One of them's going to dental school, the other one's going to medical school, and then our house, our cars. And I pay for my mom's car, her medicines. She needs medications and stuff. I help my dad.
Do you believe that you have a good support system in your family?
Yes.
I'll pass the witness, Your Honor.
Ms. Whitney?
Thank you, Your Honor. Mr. Rios, let's
Yes.
talk about the incident that occurred on January 27th of 2019, the Lavernia incident. You were asleep at an intersection, correct?
Yes, ma'am.
And it took quite a bit of time for the officers to actually wake you up, correct?
I wasn't aware of that.
So, have you not had a chance to look at the offense report where the officer talks about banging on the window to try to wake you up and he couldn't wake you up?
No, I know he banged on the window to wake me up, but I didn't know how long it took.
Okay. And do you recall telling the officer that you drank a 12-pack the night before?
The night before.
Okay. So did you drink a 12-pack or did you drink a combination of a 12-pack and then the whiskey?
It was a combination. I believe I told him combination.
Okay. So you drank a 12-pack and then how many whiskeys or shots did you have?
I couldn't tell you exactly, ma'am.
Okay. And you said you drank the night before. Did you feel intoxicated after you had consumed that alcohol?
when I went to sleep,
When you went to sleep?
yes, ma'am.
And you stated that this all occurred in Del Rio, correct?
Yes,
And then you drove into Livonia.
yes,
You agreed to do a breath test, correct? Once you were arrested?
yes, ma'am.
And your BAC was 0.178 at 11 o'clock in the morning.
Yes,
You would agree with me that if you had stopped drinking the night before, your BAC would have been much higher the night before.
yes, ma'am.
And you're telling this court that you did not feel intoxicated when your BAC was a 0.178.
When I woke up, or
Well, as you're driving, I mean, you woke up and you started driving from Del Rio and you passed out behind the wheel in Livonia.
yes, ma'am.
You said you did not feel intoxicated.
I mean, I felt fine, you know, whenever I took a shower and all that, I said, I'll be okay. And I bought me, you know, a coffee or something. I don't remember.
So you didn't feel any effects of any alcohol driving back into Livonia. That is what you're telling this court, correct?
I mean, maybe a little hungover and stuff.
Okay. And let's talk about you were arrested and you bonded out and you went before a magistrate, correct?
Yes, ma'am.
And they went over the bond conditions with you, correct?
Yes,
And you signed that paperwork.
yes, ma'am.
Did you get a copy of that paperwork?
I believe I did, yes.
Okay. And one of the conditions in that paperwork is that you're not to consume or possess any alcohol, malt beverages, or illegal drugs, correct?
Yes, ma'am.
So you knew that you weren't allowed to drink, correct?
I mean, well, I didn't read the papers, but I do remember the judge reading them to me and stuff.
Okay. Well, you read them enough to know that you needed to report to probation to get an interlock device, correct?
Well, they told me before you leave, you go straight over there and get your paperwork. I came and got paperwork, yes, ma'am.
And when you were over there, you also signed some conditions over there, correct? In regards to the interlock.
Yes,
Okay. And you received copies of all that information as well, correct?
yes, ma'am.
Okay. Now, the violations with the interlock, I mean, I understand you were telling the court that you just had a sip of alcohol on January 31st of this year, but your first violation was back on June 23rd with the interlock, and the BAC was a 0.02, correct? Or
Yes.
excuse me, June 22nd, BAC was 0.133 when you blew into the interlock device. Do you recall that and being locked out?
I didn't know the numbers or anything.
Okay. Well, do you recall being locked out of the interlock device?
Yes,
Okay. And how much had you been drinking that before you were locked out that day?
I don't remember, no, ma'am.
Okay. So you admit to this court that you've been drinking while you've been on your bond conditions.
Yes, ma'am.
And how much do you typically drink when you drink?
I mean, it depends. I mean, I don't know. When I do drink, you know, I'll sit down and cook out. I'll buy me a 6-pack or something.
So how often do you sit down and drink?
It hasn't been often, no.
Well, it's been at least 4 times because you have 4 interlock lockouts. Do you agree
Yes,
with me on that?
Yes.
Okay. So you don't know how often you drink?
I mean, well, no, I've been trying to stay, you know, trying to do good and stuff. So it's not like on my 14 days, I don't sit here and drink every day or nothing like that.
And do you drink when you go to work and when you go to work? When
No,
you're on
ma'am.
for your 14 days?
No, I'm in the middle of nowhere.
Now, you talked about the fact that you've been attending AA, correct?
Yes, ma'am.
Who is your sponsor?
I don't have one. I just go to the meeting.
Mhm. Don't you typically have a sponsor when you go to AA meetings?
If you would like one, yes, ma'am, you can get a sponsor. If you feel like drinking or something like that, you can reach out to him.
So who do you reach out to when you think you need help?
I talked to my wife. I just talked to my wife and that's it. But as far as AA, I just go to the meetings and then I would get my paper stamped and just.
And what step are you on with AA?
What do you mean? What?
Well, they go through steps. What step are you?
Oh, what step? I thought you said stuff.
No, I'm sorry, step.
Mhm. No, I mean, I just read the steps and do our daily meeting, but
Now, you said you attend these meetings via computer or via in person?
not in person.
And you said you had somebody sign something for you?
Yes, ma'am. The chairman, whoever's in charge of that day, they'll sign it and stamp it.
Do you have that with you today?
I don't have it. I believe I emailed it, but maybe it was a different lawyer or something. No.
And you didn't think that was important to bring with you today to court, to show the court?
Like I told Mr. Mario Moreno, I didn't find it. I emailed the papers and stuff. I mean,
And Mr. Rios, so Mr. Rios, you understand with AA, you must go through steps. So if you're attending AA, you should know what step you're on.
no, I haven't started any steps. You do amendments and all that, and you admit that you're powerless over alcohol and everything, but I haven't reached out or anything to anybody.
And how long have you been attending these AA meetings?
Almost a year before all the COVID stuff happened.
So you were attending before COVID. Have you been attending during COVID?
No, during COVID, they were doing them online, but I never saw the app or nothing. They closed the office for a while.
So you haven't been attending AA meetings recently?
Not recently, no, ma'am.
Okay, so it's been a little bit, about a year since you attended an AA meeting?
Almost, maybe.
Okay. Now, these other programs that you completed, the victim impact, which I think you may have referred to as the MAD, that was prior to COVID, correct?
Yes.
Okay. And then the last class, the drug offender, not the drug offender, the DWI offender class, that is something you recently completed, correct?
No, it was been a while.
Okay. And do you understand that's a class that's typically reserved for individuals that for their first DWI offense? You understand that, correct?
Yes.
So you've attended that class previously.
Yes, ma'am.
And Mr. Rios, you were picked up on the motion to revoke bond in November and you bonded out, correct?
Yes.
And even after that, you continue to consume alcohol, correct?
Yes.
And do you recall telling probation, Mr. Flores, that during the PSI that you do not need treatment? Do you
Yes,
recall
ma'am.
telling him that?
Well, I told him I felt like that I don't, because it's not like I drink every day. You know, that's what I mean. I don't feel like I'm dependent or need to drink it every day or don't go to work because of it.
Okay. All right. Thank you very much, Mr. Rios. I'll pass the witness.
Mr. Moreno?
Yes, Your Honor, just a few questions. Mr. Rios, do you Do you now, or have you ever denied that you drink alcohol?
No,
And do you agree that treatment is something that you can benefit from?
I mean, yes, I can, of course, I think I'll benefit.
I have no further questions, Your Honor.
I have no further questions for this witness, Your Honor.
Mr. Rios, let me ask you, how much alcohol can you drink that it's not a problem?
I mean, like I said, I can like a 6-pack, and then I can stop, or one beer at dinner time and stop and go to sleep, or go to, watch TV with my wife, with the kids. I mean, there's times there's alcohol at parties and stuff like that, and I don't drink. That's the reason I said I don't feel dependent on it. I'd hate to be putting my family through this.
Thank you, sir. Any other questions for this witness?
Not from defense, Your Honor.
Nothing further from the state, Your Honor.
Okay, what other witnesses?
I have no other witnesses, Your Honor. Defense would rest.
All right, and Mr. Moreno, when you're talking about some sort of treatment plan, what are you referring to exactly?
Well, Your Honor, per the, I guess, plan in the PSI, Mr. Flores referred to a community corrections facility. So I do know that is the proposed supervision plan should Mr. Rios be placed on probation. And that is a viable option. Intensive outpatient may also be another option if upon release from that facility, or in lieu of just any sort of treatment to address the alcohol use.
Okay. Argument?
Yes, Your Honor. The state, Your Honor, is asking that the defendant be confined in the Texas Department of Criminal Justice for a term of 5 years, Your Honor. This is his 5th DWI conviction. He has had 4 chances, and he's been on probation 4 other times, and none of those has seemed to work. I know they talk about the fact that he had those convictions back in the early 2000s. He was at last on probation in 2009, which, yes, Your Honor, is 12 years at this time. But how many times has he gotten behind the wheel and driven after consuming alcohol and just not been caught? He unfortunately passed out in Livonia at a stop light and was thankfully stopped at that time by Livonia PD. He had a BAC of 0.178 after he states that he hadn't been drinking for several hours. Who knows what his BAC was at the time that he stopped drinking that night before he went to sleep. He states that he felt like just fine when his BAC was a 0.78. That's pretty good indication that he is a heavy drinker. Your Honor, he continues to drink and drive, or at least attempts to drive. That's very evident by the interlock and the fact that the interlock has shut him down at least 4 times. He says he can follow and be good while he's on probation, but he hasn't even followed his bond conditions, which is with the interlock and the not drinking. This is a safety issue for the community. I understand he has a family that he seems very much love him. But he wasn't thinking about his family when he got behind the wheel and chose to down a 12-pack and several shots and drive. And he wasn't thinking about them then. The fact that he states he was attending AA classes, meetings, but on cross, he finally admits he hasn't been to any of those classes in at least a year, over a year. Your Honor, he's had multiple chances with probation. At some point, he needs to understand the consequences is that if you drink and get behind the wheel and drive, you're going to go to prison. At his 5th DWI, we would ask that the consequences be prison at this time, Your Honor.
Mr. Moreno?
Thank you, Your Honor. And no one is denying, Your Honor, or hiding the fact that this is absolutely Mr. Rios' 5th DWI. I think it's clear, and I do understand the severity of that. And as you know, his family and Mr. Rios, they understand the severity of that as well. They're not asking for you to ignore that fact. However, please take into consideration that his last conviction was, over 10 years ago, 12 years ago. And also with those prior times on probation, Mr. Rios has shown that he is a good probationer. If given that opportunity, and if he's checking in frequently, and if he's asked to do something, he's going to do it. No indication on there that he was drinking while on probation, breaking any of the conditions. So we know that he's a good probationer. That I think the evidence shows that. Now, does he make mistakes? I think, from what you've heard today, I think it's clear, yes, Mr. Rios makes mistakes. The state is asking for you to consider, how many times has he gone behind the wheel and driven intoxicated and just got away with it? Well, there's nothing here to say that ever actually occurred. I mean, what we're facing here is somebody who made a mistake again. But, as you heard from Mr. Rios, he was drinking the night before. He fell asleep, woke up, thought he felt fine, took a shower, had some coffee. But he knows now that was a mistake. He was wrong. He's addressed that with the court by taking a plea and taking responsibility for the charge. He knows that it was wrong, but at the time, he thought that he was fine to drive. Now, does that fact contribute to the high possibility that Mr. Rios has a issue with alcohol and that he's an alcoholic? I think so. And I think that's what the court is addressing here today. Is this an individual who would benefit from treatment options to address this alcohol use rather than going to prison? And I think that is what we're looking at here today, Your Honor. Again, we're not asking for the court to slap Mr. Rios on the wrist and then send him away on probation and not address his alcohol use to prevent this from happening. What we want is we're asking the court to place him on probation, and then also we would agree a 6-month to 24-month stint with a community corrections facility would be probably a good option for Mr. Rios. And I think he would agree with that he would benefit from some treatment options like that. We don't know if he was given these opportunities in these 4 prior DWIs, or if they simply just placed him on probation, asked him to do a course or 2 and to check in. So for him to have this opportunity to address this issue, to make sure that this doesn't happen again, and then also would help to guarantee the safety of the community, I think that would be a better option for Mr. Rios. We know that, he's a hardworking man. He does what he can to keep his family afloat and to keep a roof over their head and keep their mouths fed, keep his kids in school, to deprive them of such a strong figure in the home when there's an opportunity for him to address these issues and not be sent to prison. I would just hate to see that, Your Honor. I mean, these are good people, and I think Mr. Rios is a good person. I just think he made a bad decision. But I know that he's willing to address those issues with the court and with probation, and he's wanting to take responsibility. He's willing and ready to do anything that the court orders so that he can get this behind him and make sure that this doesn't happen again. We would ask for the court to place him on a probation term, and then also, move forward with this proposed supervision plan from the PSI given by the probation officer. Place him in the community corrections facility, and then once upon his release, if he has to continue with some outpatient treatment, if that's what the court feels is best, I'm sure that he wouldn't have an issue with that either. And then continue with AA at the very minimum 2 times a week as directed by his probation officer. Successfully complete any other programs or treatment options that he has available to him, if they're made available. So that'll be that's the request from the Mr. Rios today, Your Honor, and we hope that you would take that into consideration when making your decision. Thank you.
All right, anything else, Ms. Whitney?
Nothing further, Your Honor.
Mr. Moreno, have you had an opportunity to discuss with your client that, I don't know what the parole laws, they're always subject to change, but that he might actually wind up spending more time in a lockdown facility if he goes to treatment than he would if he just goes off to prison and has a chance to be out on parole?
I haven't had that conversation with him yet, Your Honor, but the conversations I have had with him were just wanting to address the alcohol use. And like I said, I think that's the concern for the court would be, and the community as well, how do we prevent any further actions like this?
All right, I've read the pre-sentence investigation report. I've gone back and reread the offense report. I've listened to the testimony carefully. Mr. Rios, the answer to how much can you drink without it being a problem is none. All right. You said that you had heard him discuss the first step in Alcoholics Anonymous, which is admitting you're powerless over alcohol. I don't know if powerless is the best term of art there. Not everyone who drinks too much, too often, drinks until they're falling down drunk. But it still doesn't mean that they're not an alcoholic. That can be a hard thing to admit. It's been a hard thing for me to have to admit to myself and for everyone else. So I will find you guilty if I have not done so already. I think I did so because there's no deferred on this. I will sentence you to 5 years, probated for 10 years with court cost, $1,000 fine, 200 hours of community service restitution, and all the terms and conditions, including 6 to 24 months in a treatment facility that were recommended by Mr. Flores in his pre-sentence investigation report. And I guess what I'll say, and I don't want this to come across the wrong way, but I don't want a good probationer. I want a sober citizen. And I would much rather have somebody who just almost gets revoked 3 times, but then finally gets it and straightens up and does not drink anymore. So we don't have to worry about them drinking and driving. Then has somebody who manages to go out there and complete the probation time after time, but keeps drinking. And all they're doing is just saying, I'm going to be a slightly better disciplined alcoholic until I get off probation, and then it's party time. So is there anything else I need to do before sentence is imposed?
Your Honor, are we going to also include the $100 EMS fee?
Yes, whatever additional court costs there are. All right then. So I will sentence you to 5 years, probated for a period of 10 years with all the rest of the terms and conditions of your of the probation plan that was described by the probation officer in the pre-sentence investigation report, including the community service hours and the fine that I said. And what was that, 200 hours and $1,000 fine?
Yes, Your Honor.
Okay. You understand, sir, that because I have followed the 5-year cap in this case, that you have waived the right to appeal and you may not appeal?
Yes, Your Honor.
All right. And stuff about Mr. Rios being a good guy, I don't doubt any of that for a bit. I've got to say that, you know, if I was throwing a dinner for attorney friends, some of the ones I see at the attorney AA meetings, there'd be a lot of them invited. Salt of the earth people, hardworking, but they come to understand that they can't use alcohol. And you need to come to understand that, Mr. Rios. I've had to come to understand that. I don't like it. I wish I could go out and have a few drinks and just let it be, but too often I don't when I drink, so I don't drink. So I hope that this works with you. I will certify to the Court of Appeals, as I've said, that you've waived the right to appeal, and I will sign the judgment whenever it comes to me.
And I will get started on the judgment right now, Your Honor.
And I just missed a call from spam risk, so we will not interrupt court for that. All right, are we ready to start on the Longbow?
State's ready, Judge.
Lofbaum plea, or not plea, but case. All right, is he at the Wilson County Jail? Are they online?
He is at the Wilson County Jail.
There he is, I see. All right, howdy, Kelly. All right, if we could get him in, I'd appreciate it. Mr. Lochbaum?
And Your Honor, before you proceed, I apologize. Is Mr. Rios going to be taken in today, or is he allowed the 14 days to turn himself into the Wilson County Jail?
Believe the recommendation was that he remain in the Wilson County Jail until he transports. Did I read that correctly? Defendant shall turn himself into, it says 14 days prior, but it says remain in custody of the Wilson County Jail. It says both. All right, Mr. Flores? On
Yes,
the
Your Honor.
supervision pen, page 11.
I'm sorry, we do either or. Right now, the waiting list is pretty quick, within 2 weeks. So what we can do is get a date and have him go in or just go into custody. The very last person I had was exactly 2 weeks.
He needs to go into custody today.
It'll probably be better.
All right.
Thank you, Your Honor.
I also find the defendant made his post-trial waivers knowingly, intelligently, and voluntarily. Right, Ms. Sawyers, I've saved the plea package with a new date on it. With today's date.
Okay, thank you.
They're getting Mr. Lockbaum now, sir.
Thank you.
Hello.
Okay, and do I have this file? If I could get the file, is that over here on the desk or on Lockbaum?
On my way with it.
Thank you, ma'am.
Very helpful. Just trying to look it up. Here's a bench warrant to leave here to the office.
All right, here, let me go ahead and sign it. All right, thank you, ma'am.
Your Honor, am I needed for anything further or may I be excused?
No, sir, you're excused. Thank you.
Thank you, Judge. You have a good day.
All right, was that Mr. Lockbaum at the jail?
It is, Your Honor.
There he is, Your Honor.
All right, we're on the record in for the habeas corpus 21-0002 in Ray Douglas Edward Lockbaum. Is the state ready?
Ready, Judge.
All Right now, the attorney for Mr. Lockbaum, the Texas Rural Legal Aid, has filed a motion to withdraw his counsel, saying that Mr. Lockbaum wishes to represent himself. So is, Mr. Lockbaum, do you wish to represent yourself in this matter?
My honor, I am the executor of the estate. Chancellor, we need to move the court into a chancery in camera before discussing the estate. I am here in good standing. I am the executor over the estate you are charging. The estate is in full faith and credit, and I am presenting this for you to discharge the charging instrument as I am the executor. The estate is the entity and not.
All right, Mr. Lockbaum, I'm going to interrupt you and let you know that
I am demanding
I am not going to.
this case be dismissed.
I am not going to entertain any discussion about whether or not you are a human being who is charged as a human being here in the district court in Texas. My only question right now is, do you wish to represent yourself? Or do you wish Texas Rural Legal Aid, who was appointed to represent you because you were indigent, to continue to represent you? So what is the answer to that question, sir?
Thank you, my honor. I present myself, and I do not need representation. And I'm asking for a preliminary hearing to determine.
All right, no, we're going to stop right there. We're going to stop right there. So you are asking to represent yourself.
I present myself.
Okay, I'm not talking about presenting yourself. You're not a piece of commercial paper that has to be.
Absolutely not.
Okay. Are you going to act as your own attorney in this matter?
I'm a living man. I will represent myself.
Okay, I'll take that as a yes. I need to caution you, sir, that one, I think that is generally a bad idea for someone who is not an attorney. Two, for someone who is an attorney, I think it's always generally a bad idea for someone to represent themselves. Two, I need to tell you that extradition is an odd type of case that's sort of off by itself. It's not really civil. It's not really criminal. It's a little type of case all by itself. And even if you think that you have knowledge about criminal law or civil law, even if you're correct, that doesn't necessarily mean that you would know anything about extradition law, because it's an odd thing off on itself. The other thing I'll ask you is, did you ever play baseball, sir?
I have played baseball.
Okay. When the baseball game starts, the managers come out and they hand their lineup cards to the umpire. Would you agree with me? That's what's supposed to happen when the baseball game starts.
The baseball games that I played, I never handed a lineup card. There was a roster.
Okay, so if you go a bit more formal into organized baseball, is there a lineup card that's handed into the umpire?
If you say so.
Okay. And sir, if one of the teams sends the wrong player up to bat, it's not the player they have listed on the card, and they're trying to bat in violation of the rules. What is the umpire's job when that happens?
I don't know, sir.
The umpire's job when that happens, sir, is to say, play ball. Now, if the manager for the other team says, I protest, they're batting out of order, well, then the umpire takes action. So I guess what I'm also asking you, sir, is do you understand that as the judge, I'm like the umpire? I will rule on objections and protests, but I don't go in and tell people, hey, you know, you need to object. That's hearsay this other side's coming up with. Or if it is an objection for hearsay, I don't go in and say, well, you know, it's probably excited utterance exception. My job is to rule on whatever protests or motions are made to me, not to suggest to someone what they should do. Just like the umpire in the baseball game doesn't suggest to the manager of the other team that he ought to protest because somebody's batting out of order. Do you understand all that?
I hear you.
And do you still wish to represent yourself?
My honor, I am the executor of this estate. I will present myself. I'm a living man. And I'm not the entity that's on this
All right.
paperwork.
That's all we need. I will take that as a yes. And I will sign the order on the motion to withdraw counsel. I will find that Mr. Lockbaum made his decision to proceed without counsel knowingly and knowing that he had the right to appoint her to counsel. So 3/2/21.
My honor, may I ask you a question?
Yes, sir.
Who appointed Trala or Kathy Starling?
Sir, I appointed the Texas Rural Legal Aid to represent you. Now, where do we stand?
Well, I guess a couple of things, Judge, is a matter of housekeeping. Over a week ago and also yesterday, I sent the 4 exhibits the state plans to introduce to the court and also to Mr. Lockbaum's counsel, Ms. Starling. I don't know if he has seen those or not seen those now that he's acting as his own counsel.
Mr. Lockbaum, have you received copies of exhibits that the state wishes to try and introduce?
Not that I'm aware of.
Okay.
What exhibits Mark, what exhibits are you speaking of? What?
Well, let me ask Mr. Leday to post them. And let me ask, does the jail have any way to print documents there?
Yes, sir. That can be through email.
Okay, if you would email them to the sheriff's department, to booking, or the jailer, or whoever it needs to be emailed to, so they can print those out and Mr. Lockbaum can have a chance to look at them.
Okay.
And
Kelly, what email address would you like me to send those to?
Let me find out for you. Give me a second.
Mr. Leday, you can email them to me and I'll print them out real quick.
Okay.
all right, and what happened to Mr. Keendaws? Are we still doing pleas on any of his clients today?
Yes, sir. He was back on here just a minute
Yes.
ago and said he was ready to go.
All right.
I can follow up with him, Your Honor.
All right, I thought perhaps we could, while we're waiting for that to happen, get a plea done on his case.
Okay, yes, we still do have 2 to do on James Sellers and then an open plea with Sean Spalding, and Mr. Spalding is here. Mr. Sellers is in custody.
Are they waiting on me to review this?
No, they're waiting for your documents to come in.
That's what I'm saying. They're waiting for me to review the documents.
Yes.
we've now moved on to another.
I'm not sure, whatever they say.
My honor, are we still proceeding with,
Lockbaum, we're in recess until we get copies of the state's proposed exhibits to you and you have an opportunity to look at them.
Judge, just so we know, what I've sent over to him is what I've sent to the court, which includes the governor's warrant, which is 90-something pages. That's why I was asking if Ms. Starling had already produced this to him and he's had a chance to review it. Otherwise, my fear is the witnesses that I have on and have had on several times will sit here and then at 5 o'clock, oh, sorry.
I understand, but let's get a copy to Mr. Lockbaum. All right, and those documents been given to Mr. Lockbaum?
Yes, sir, they were given to him.
He's reviewing them right now.
My honor, are you requesting that, and Mark, are you requesting that I review all 90 some pages of this exhibit right now and we proceed to move forward? Is that what you're
Since you're
Are you telling me that you should address your questions to me and not to the attorney for the state? All right. Are you ready to proceed, sir?
My honor, I need some time to review this this exhibit. 90 some pages. Last time we met that.
Right. Have you seen that exhibit before?
I don't believe I've seen this. No, it looks different to me.
Have you seen the documents inside that exhibit before?
Not until I have a chance to review them. No, I can't say that I've seen them. No.
Okay. How much time do you need?
I need a lot of time, sir. In order to grasp what this instrument is, which I have a lot of challenges with at this point. I don't see the Tennessee portion of this.
All right, sir. I do not know what you have in front of you. Mr. Leday?
Your Honor, I merely forwarded the same email that I sent to the court and Ms. Starling earlier. It is the electronic copy of the full Texas warrant with accompanying documents, including the request by the Tennessee Executive Chamber. It is a fingerprint card and booking sheet from Madison, Tennessee Sheriff's Office, and is also a fingerprint card from Wilson County Sheriff's Office. And those are my 4 exhibits.
I don't see the requisite. I don't see anything pertaining to Tennessee and William Byron Lee. What page is the Tennessee governor's warrant duly executed by William Byron Lee, who's the Tennessee governor? Because it's not Bill Lee. I know that for sure. For his oath of office.
Mr. Leday?
This appears to me to be a false instrument.
All right, Mr. Lockbaum, speaking to the other attorney, to the attorney. All right.
Your question, Judge?
Is there a governor's warrant from Tennessee in that stack?
There is, Your Honor, on State's Exhibit 1, which starts out with the governor's warrant from Texas. The last 2 documents are from the governor's office in Tennessee. So at the very, very bottom, if you scroll down.
Okay, I see.
My Honor, I'm asking for a preliminary hearing to determine jurisdiction and the standing of the prosecutor to bring charges against me. And I'm stating plainly that I'm living flat.
The only thing we're here on is the writ of habeas corpus to test the governor's warrant here in Texas, which includes in supporting paperwork from the state of Tennessee. So did you see the last 2 pages, pages 94 and 95 in State's Exhibit number 1, which are titled Tennessee Executive Chamber?
I don't believe I have the same instrument that you're speaking of, My Honor.
Okay. What's the very last page that you have on State's Exhibit number 1?
Appears to be a false instrument,
Okay.
a derivative of my copyrighted trade name,
What's the title of it?
blank criminal.
All right. Let me ask the Sheriff's Department, was the entire 95-page State's Exhibit number 1 given to a copy of it to Mr. Lockbaum?
Yes, sir. Everything that Mr. Lede sent me, I printed out and gave to the officer to give to him.
Ms. Lockbaum, I've heard you say that you didn't see it, and I've also heard you say that you thought it was a forged or fake instrument. Do you have a copy of the governor's warrant from Tennessee that says State of Tennessee Executive Chamber at the top?
I'm still looking for it, Your Honor, or My Honor, I should say. And just to clarify for the record, I never said that it was forged. I believe it's a false instrument.
Okay.
Masquerading. warrant. It appears to me to be an impound order of some sort. But it's
Well,
just,
apparently you do have it because you've seen it.
I'm sorry?
Apparently you do have a copy of it.
Well, I have a copy of what was given to me today,
Okay.
for the record. As I'm reading through it, I share with you based on where I'm at and reviewing the 90+ pages that I'm supposed to review in this hearing, what I can share with you that are false instruments, derivatives of my copyright and protected trade name are being used by what appears to be foreign enclaves, state of and county of, that are evading the Constitution of the United States and Constitution of the United States of America, Amendment 11.
All right. And so, Mr. Lockbaum, what I need to ask you then is, are you announcing that you're ready or not ready to proceed on the writ of habeas corpus?
My Honor, I'm just kindly sharing with you where I was at and reviewing the pages so far of this instrument, this false instrument that I'm claiming is a false instrument. But I still need time to review. There's a lot of laws that have been broken on this instrument. That's for sure.
All right, sir, and you understand that I'm not asking you to give me a précis of whatever lawsuit you think you might have to bring to seek redress that you believe you're entitled to. I'm asking you on the narrow question of, does the Texas governor's warrant show that the Tennessee governor has requested your extradition and that at least one of the offenses your extradition is requested for is a felony? And that they've described it, the alleged offense, and described you. That's what the hearing today will be over, that and nothing else.
Minor, on what basis in fact or evidence does the court presume jurisdiction related to American standing under the public law? I think that'll help in regards to discussing this instrument.
All right, Mr. Lockbaum, you're standing in Wilson County, Texas. I'm the district judge for Wilson County, Texas. I have jurisdiction. All right, so I understand you're saying that you're not ready, but I will still proceed. Mr. Lede.
Okay. Your Honor, at this time, I would call Captain Tom Rudder.
Okay, why don't we get all of the witnesses sworn in at once? In just a moment. All right, so what all witnesses does the state have?
Your Honor, we have 3 witnesses. It'll be Captain Tom Rudder with the Madison County Sheriff's Office. We will have Lieutenant Heather Reyna with the Wilson County Sheriff's Office, and Todd McCrone with the 81st DA's office.
All right, will each of you raise your right hands? Each of you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and Captain Rudder, your full name is?
Tom Rudder, Tom, Tom Rudder.
All right, and Lieutenant Raina? Your full name is?
Heather Reyna.
Okay. And Investigator McCrowan?
Yes, sir. Todd McCrowan. Yes, sir.
Go ahead, Mr. Leday.
Thank you, Judge. Captain Rudder, this is Mark Leday with Wilson County. Can you hear me, sir?
I can, sir.
Okay. You and I have talked a number of times. Is that correct?
That's correct, sir.
Okay. And in those talks, you and I have discussed particularly 2 documents. Do you know what those documents are?
I believe you asked me about a fingerprint card and a booking intake sheet.
Okay. And do you have a copy of those with you?
I do.
Now, let me ask you a question. For the hearing, we're going to talk about the Tennessee fingerprint card as State's Exhibit 2 and the Tennessee booking sheet as State's Exhibit 3. You understand what I'm saying?
Yes, sir. I do.
Okay. So let's talk about State's Exhibit 2, the Tennessee fingerprint card. Are you looking at that now, sir?
I am, sir.
Okay. What does that contain?
It contains the fingerprint upon the arrest of Douglas Edward Lockbaum in Dare Jail.
Okay. And now, what do you do for Madison County Sheriff's Office, sir?
I'm the jail administrator here.
Okay. And so you're familiar with the practices of the Madison County Jail in Tennessee?
Yes, sir.
Are fingerprint cards like we're talking about in State's Exhibit 2, are they kept in the ordinary course of business?
Yes, they are.
And is it a common practice of the Madison County Sheriff's Office to keep those records?
Yes.
Okay. And as the person in charge, would you be a custodian of those records?
I would be.
Okay. And when somebody is brought into the Madison County Jail, do they go through a booking process?
They do.
Okay. And State's Exhibit 2, that fingerprint card, is that completed at the time?
Yes, it's part of the process.
Okay. And it's completed by an employee of the Madison County Sheriff's Office?
That's correct.
Okay. So the person that made this card would have personal knowledge of the contents therein?
Yes.
Okay. Now let's talk about State's Exhibit number 3, which is a booking sheet. What does that contain?
It contains the information on the person being processed in, as far as name, date, age, race, charges, that type of stuff.
Okay. And in regards to State's Exhibit number 3, who is this a booking report for?
Douglas Edward Lockbaum.
Okay. And similar to State's Exhibit 2, is this kept in the ordinary course of business of the Madison County Sheriff's Office?
That's correct.
And it's common practice for y'all to keep these documents?
That's correct.
And you would be a custodian for this document as well as State's Exhibit 2?
That's correct.
Okay. And the person that enters the information would do it at or near the time that an inmate is booked into your jail?
That's correct.
Okay. Judge, at this time, we move that State's Exhibit number 2 and 3, the Madison County fingerprint card and booking report, be entered into evidence. I do not want to post them, share documents, Judge, just because it contains private information that I don't want to broadcast over the internet.
I understand that would not be fair to Mr. Lockbaum. All right, Mr. Lockbaum, do you have legal objections to the admissions of State's Exhibits 2 and 3?
By what possible acts of barratry have these prosecutors brought false charges against legal fictions, tried to act in our own names against me, my children, my wife?
All right, again, Mr. Lockbaum, I am only asking at this time whether you have any legal objections to the admissibility of these documents?
Would you like me to restate my question, my honor?
Yes, sir. You were asking a question. My question to you is not answerable properly by a question. My question to you is, do you have legal objections to the admissibility of State's Exhibit 2 and 3?
Well, I would ask again, my honor, maybe I'll rephrase this. What excuse do these prosecutors have? It's addressing and or impersonating me as a foreign person, alien, with respect to my country, house, and home.
All right, without objection, State's Exhibit 2 and 3 are admitted into evidence.
Thank you, Judge. Captain Rudder, in regards to State's Exhibit number 2 and 3, do they both contain the name of who these fingerprints and this information belongs to?
That's correct.
Okay. And do they provide identifiers such as a date of birth without giving me the actual date?
They do.
Okay. Looking at State's Exhibit 2 and State's Exhibit 3, is it the same date of birth?
That is correct.
How about age, height, and weight? Do all those match across from State's Exhibit 2 to State's Exhibit 3?
They do.
What about Social Security number, Captain? Are they on both exhibits?
They are.
Okay. And without saying the number, is it the same number?
It is.
Okay. Now, looking at State's Exhibit 3, the booking charge, what offenses was Mr. Lockbaum booked into the Madison County Jail for?
You'd like me to read each of them?
Well, are they repetitive?
Yes, sir.
Okay. Well, it just
I don't mind reading them. I just want to make sure.
you don't need to read every one if there's multiple violations, but just if you could read the different things that he is booked for.
There's multiple violations of order of protection. There is multiple violations of harassment, multiple violations of stalking. Looking to see if there's anything outside of that.
And let me ask you a question, sir. Is aggravated stalking a felony in the state of Tennessee?
Yes, sir. Aggravated anything is a felony in the state of Tennessee.
Okay.
There's also, in addition to those, there's a contempt of court. There's an ex parte order of protection entered. And the rest of the same of the others.
Thank you, Captain. I have no further questions.
All right, Mr. Lockbaum, what questions do you have for this witness?
None.
All right, then. May Mr. Rudder be excused?
By the state judge.
All right. Mr. Lockbaum, do you believe that you're going to need to recall this witness? Or can he be released to leave the hearing?
His testimony is his word. It's on record, correct?
Yes.
I have no questions for him. Thank you, Captain Rudder.
All right, you are excused. Thank you
Thank you, Your Honor.
for your time. Mr. Leday.
Your Honor, at this time, the state would call Lieutenant Heather Reyna with the Wilson County Sheriff's Office.
Go ahead.
Lieutenant Reyna, what's your current occupation?
I'm in corrections. I'm a correctional officer.
And you are a supervisory position at the jail?
Yes, sir.
Okay. And you and I have also talked, and you and I have talked about a very specific document, correct?
Yes, sir.
Okay. And you have that document in front of you?
Yes, sir.
Okay. I'm going to refer to it as State's Exhibit number 4. What is that document, ma'am?
It's the fingerprint card
Okay. And the fingerprint card of whom?
of Douglas Edward Lockbaum
And why? Where is Mr. Lockbaum currently located?
in Wilson County Jail.
Okay. And why is he located there?
He had an out-of-state warrant for stalking, a failure to appear.
Okay. And so let me ask a few questions about State's Exhibit number 4. Now, as your supervisory position with the Wilson County Sheriff's Office, are you custodian of records there?
Yes, sir.
Okay. And the fingerprint card that we're talking about in State Exhibit 4, is that collected in the ordinary course of your business?
Yes, sir.
Is it a common practice of Wilson County to collect documents of these type?
Yes, sir.
Okay. And when you book somebody into your jail during the processing section before they're put in a cell, is this document made and they're fingerprinted?
Yes, sir.
Okay. And it's made by an employee of Wilson County Sheriff's Office?
Yes, sir.
And so they would have personal knowledge and make this record known at or near the time that the event occurred?
Yes, sir.
Okay. So at this time, we'd ask that State's Exhibit 4 be admitted into evidence.
Mr. Lockbaum, do you have legal objections to the admission of State's Exhibit number 4 into evidence?
Honor, I challenge the jurisdiction of this court and the standing of the prosecutor to address me.
All right.
Object to
To the
I
extent
challenge the jurisdiction of this court and the standing of the prosecutor to address me.
all right, I will overrule those objections and admit State's Exhibit number 4 into evidence.
Okay. And Lieutenant Reyna, in regards to this, this contains all type of identifiers for Mr. Lockbaum,
Yes, sir.
date of birth, social security, and so forth.
Yes, sir.
Okay. And you physically have Mr. Lockbaum in your jail and have just now given him paperwork, correct?
Yes, sir.
And additionally, it has a picture of Mr. Lockbaum up in the top right corner.
Mm-hmm.
How was that picture put in there?
We take their picture upon doing their fingerprints.
Okay. Judge, I have no further questions for this witness.
All right, sir, what questions do you have for this witness?
Heather Reyna's testimony is on record, correct?
I'm sorry?
Heather Reyna's testimony is on record?
Yes, sir.
I have no other questions for her. Thank you, Heather Reyna.
Does either side expect they will wish to recall this witness?
Not from state, Your Honor.
All right. Mr. Lockbaum, do you expect that you're going to need to recall this witness to testify later?
Can you define later for me, My Honor?
Okay, I'm later in this hearing. Today.
I don't believe so, no.
All right, I expect she'd still be at the jail, but all right, you are excused at this time.
Thank you.
All right. Mr. Leday?
Your Honor, at this time, we would call Investigator Todd McCrowan.
Go ahead.
Investigator McCrowan, state your current occupation, please.
Yes, sir. I'm an investigator with the 81st Judicial District Attorney's Office.
Okay, and that's in fact the same office that I work for, correct?
It is, yes, sir.
Now, as part of your, well, in addition to your duties as an investigator, have you ever served as any type of expert?
Yes, sir, I have.
Right. And what field is that?
Fingerprint identification and footwear examination.
Okay. And have you testified as an expert in fingerprint examination in the state of Texas?
Yes, sir, many times.
Okay. How are you capable of doing this? What are your qualifications?
I have training going back to basic fingerprint from the Lubbock County Sheriff's Academy, which was 40 hours, to advanced latent fingerprint, the Texas Department of Public Safety Training Academy, which was 40 hours, advanced palm print identification, Montgomery County Sheriff's Academy, 24 hours, and additional trainings throughout my 20-something years.
Okay. And is there any type of certification that Texas requires to testify as a fingerprint expert?
No, sir.
Okay. And how many times would you say you've testified regarding fingerprint comparison?
Hundreds, or maybe more.
Over how many years?
Over 20, 25.
And you've testified in state and federal court?
I have, yes, sir.
Okay. And have you testified as an expert in fingerprint comparison outside the state of Texas?
Yes, sir, I have.
Okay. Where was that?
Montana.
In regards to this case, have you done were you requested to do any comparisons?
Yes, sir, I was.
Okay. We've been talking about the Tennessee card, State's Exhibit number 2, and the Texas card, State's Exhibit number 4. Have you seen those documents?
Yes, sir, I have. Yes, sir.
And are those the 2 documents you were asked to compare?
They were. Yes, sir.
Okay. And by what process do you compare us? Walk us through that quickly, if you would.
I compare the 2 prints with ink fingerprints. It's pretty simple compared to a latent. I just looked for the same fingerprint pattern. If they have the same fingerprint pattern, I continue my examination and continue my look at the prints, and then I go into smaller details such as bifurcation, ridge endings, dots, and if those are found in the same spatial location on either print with enough number or great enough amount, then it's said to be an identification.
And in regards to everybody living in the world, do they have their each unique fingerprint?
Yes, sir, they do.
In the course of your testifying as an expert in your years of study, has anybody ever been misidentified by fingerprint, meaning that a stranger has the same fingerprints as another stranger?
No.
Okay. You've never read about that or even heard about that?
No, sir.
Okay. In regards to your comparison of State's Exhibit 2 and State's Exhibit number 4, were you able to reach a conclusion?
Yes, sir, I was.
Okay. What is that conclusion?
That they are one and the same, from the same individual.
Okay. So the State's Exhibit number 2 of Douglas Lockbaum from Tennessee is the same individual as State's Exhibit number 4, Douglas Lockbaum from Wilson County.
Yes, sir.
Okay. And did you look at the identifiers across these 2 documents?
Yes, sir, I did.
Okay. And in regards to birth date, social security number, were they the same or were there any discrepancies?
They were the same.
Okay. And your opinion that you're rendering the court today in regards to fingerprint testimony, is that based on your training and experience?
It is.
Judge, I'll pass the witness.
Well, Mr. Lockbaum, do you have questions for this witness?
Yeah, Todd, thank you so much for your background, your experience. Todd, based on your experience, am I a living man?
Yes, sir.
I am. Thank you. I'm a living flesh man, living blood man.
Yes, sir.
Okay. So would it be fair for you to say, based on your years of experience, that I'm not a corporation?
Yes, sir.
That I'm not a legal fiction?
Yes, sir.
Not an individual, not a person, which can be a man or a woman. I'm a living flesh and blood man.
Well, I think a person is an individual, I guess. It depends on how you define that, I guess.
Am I an artificial person?
No.
So you would agree with me that I am a living flesh and blood man?
I'm going to object as asked and answered.
Sustained.
Am I owed the Constitution of the United States or the Constitution of the United States of America, both, as a living flesh and blood man?
Are you, I don't understand your question, sir. What, you said you're owed?
Am I owed the Constitution of the United States or the United States of America, both? As a citizen of the United States, as an American state national, am I owed the Constitution based on your experience as a living flesh and blood man?
As a citizen, you're protected by the Constitution of the United States. That's what you're.
Thank you for that. What's the difference between a U.S. citizen and a citizen of the United States?
Judge, I'm going to object. Calls for a legal conclusion.
Right. Mr. Lockbaum, your response to the objection?
Whose objection? Mark's objection?
Yes.
Well, I'm simply asking Todd, based on his years of experience under public law and by his oath to uphold the Constitution, he should be able to answer that question. What's the difference between a US citizen and a citizen of the United States, unless he does not have an oath or he has a false oath? I'm just, based on his years of experience that Mark had Todd clearly defined.
I'll sustain the objection.
Todd, can you explain for the court on record what the difference is between a capital U period, capital S period citizen and a citizen of the United States?
Same objection, Judge. Legal conclusion.
Sustained.
Todd, would you agree that I'm a living flesh and blood man? Just to close this out.
Yes, sir.
Okay. And then on the exhibit, Mark had mentioned the fact of my name, Douglas Lockbaum. What is the name on the exhibit that Mark wants to put into the court record, Todd? How am I identified on there?
Douglas Edward Lockbaum.
And could you kindly spell in uppercase, lowercase, as you see on your instrument, so I can verify that I'm looking at the same document? Again, I was given 90+ pages of instrument to review as we were proceeding today. When I believe the last time we had a hearing, Mark couldn't process a writ of habeas corpus that was a few pages long that extended us to today. So just to clarify with the court, Todd, how is that name spelled on the two instruments that you're looking at? If you could be specific for me, please, with caps.
Capital LOCHBAUM, comma, capital DOUGLAS, capital EDWARD.
And is that for Texas or Tennessee?
That's for both.
That's for both. Thank you. And then when you said capital, are you, to clearly state, are you saying that each letter is capitalized?
Yes, sir, I am.
So just to clarify, on record, capital L, capital O, capital C, capital H, capital B, capital A, capital U, capital M.
Yes.
Comma, capital D, capital O, capital U, capital G, capital L, capital A, capital S.
Yes.
Capital E, capital D, capital W, capital A, capital R, capital D.
Yes.
And the variation of that name reads Lockbaum, all caps, comma, Douglas, all caps, Edward, all caps.
You asking me or?
Yes.
You stating? Yes, yes.
Thank you. And I appreciate you, your response, Todd. And Todd, can you just state one more time your background for me? Again, I have a lot of moving pieces with 90 pages here and multiple exhibits that are being entered into that I need to digest in a very short period of time, where I believe, again, last hearing, it was only a handful of pages that the DA's office could not digest, where we had to extend this for a week. What's your background, Todd?
You want me to start over from where I was at, or?
You can give me the 30,000-foot view, Todd. It's on record. I appreciate you.
I have a associate degree in law enforcement, Wharton County Junior College. I have a bachelor's degree with a major in criminal justice from Midwestern State University. I have numerous trainings in latent fingerprints, all the way from Lubbock County Sheriff's Academy to Texas Department of Public Safety Training Academy to Montgomery County to Sam Houston State University. Prior to working here, I was the supervisor with the Houston Forensic Science Center over the latent print section. And prior to that, I was the supervisor over the impression evidence section of the Department of Justice, Montana Department of Justice, Forensic Science Division.
Thank you so much for that, Todd. I appreciate you. And again, my apologies to you for not having been able to write down that information and needing that recap from you. Todd, this appears to me to be an illegal contraband, seeking to human traffic me and the progeny, my children, to impound my living body under false arrest and impoundment orders, misrepresented as warrants. From where you sit with your oath, is this a matter of law or a matter of legal controversy? Is this a legal matter or a lawful matter, in your opinion?
As far as you
Does
having,
object again, calls for a legal conclusion.
I'm just stating his opinion on legal or lawful, if he knows the difference between that.
can I answer, Judge, or?
I will sustain the objection.
Well, just to clarify, Todd, thank you for your transparency today. It's much appreciated in regards to clarifying and stating that I am a living flesh and blood man. I do appreciate that. And clarifying what the name or derivative of the name is on the exhibits that Mark has just put into exhibit, which again, I'm challenging and objecting to significantly. So thank you so much, Todd. I appreciate your transparency.
Yes, sir.
All right, Mr. Ledeen.
Judge, I would ask at this time that State's Exhibit 1, the Texas warrant, along with accompanying documentation, including the Tennessee application and executive chamber order, be admitted to evidence. It's a certified document under Rules of Evidence 902, and therefore should be admissible for its purpose.
All right, and Mr. Lockbaum, do you have an objection to the admission of State's Exhibit number 1 as a certified document?
My Honor, I would just ask, what is the name of the governor? I don't necessarily have that instrument in front of me with 90 pages to search for it. What is the name of the governor of Tennessee? I guess you're saying that it's a requisite. What's the name of the governor? Can anybody share that with me? Mark, maybe you can pull it up while you have it. I believe you said it was in the back of the instrument. What's the name of the governor of Tennessee? Please.
You know, I showed the signature as best I can make out, might be Bill Lee.
Now, is this instrument supposed to be duly executed, meaning that it has weight, authority, that it's cloaked in regards to acting under the authority of the state and the governor of Tennessee? Is that what we are all agreeing to at this point? Is that what you're stating, Mark, with Bill Lee? I just need help, because again, it's 90 pages in a matter of about 10 or 15 minutes that I'm having to digest, along with asking questions of. I've not been able to prepare for this. I've already claimed on the record and stated plainly that I object, and I'm asking for a preliminary hearing to discuss jurisdiction. But since we're proceeding, I need help. Mark, are you claiming that this is a duly authorized instrument from the governor of Tennessee with his signature on it, and his signature is Bill Lee, and that should match his oath of office?
Your Honor, I'm just informing the court I'm offering into evidence as State's Exhibit 1.
If I had an
Do
opportunity.
you have an objection, Mr. Lockbaum?
Well, absolutely. The Tennessee governor, his oath of office under the Secretary of State website of Tennessee, and Todd or somebody else can look this up, his oath of office is William Byron Lee. Nowhere on the oath of office for the Tennessee governor does it say Bill Lee. Bill Lee does not have authority. Bill Lee does not exist as the governor of Tennessee or Tennessee governor. And that's correct.
I'm going to find, Mr. Lockbaum, that you have a fundamental misunderstanding of the effect of a signature, and I will overrule your objection and admit State's Exhibit number 1 into evidence.
Thank you.
Okay. Does the state have anything else?
Your Honor, due to the nature of defense that we've seen, the state has not had Investigator McCrone go and physically fingerprint Mr. Lockbaum. I will provide that State's Exhibits number 2 and number 4 from the Tennessee location and from the Texas location both include a photograph of Mr. Lockbaum, which is certainly more clear in the exhibits that we've sent to the court than it is in State's Exhibit number 1, which are copies. Should the court require, we can send, and at the court's order, we can send Investigator McCrone over to fingerprint him now if there's an issue as to identification. Otherwise, we would rest.
All right. Ms. Lockbaum, do you wish to have your fingerprints taken again?
Do I wish to have my fingerprints taken again? I've never had my fingerprints taken.
And did you see State's Exhibit number 3 and number 4?
Again, Your Honor, or I should say, again, my honor, I've challenged jurisdiction of this court. I've objected to this proceeding till jurisdiction has been proven. And I've been given a stack of 90 plus instruments and documents to look at and digest while I'm presenting myself as a living flesh and blood man to this court. And so to say that I've had a chance to review and look at it, I have not. I feel this is again, I'm challenging the jurisdiction of this court and the prosecutors to address me.
Right. I mean, Ms. Leday, you may act at discretion. I am not requesting any additional evidence. And I do not hear that Mr. Lockbaum is requesting that his prints be taken again in order to demonstrate that he is not the individual sought in the warrant from Tennessee. So does the state have any other evidence?
In that case, Your Honor, the state would rest.
Mr. Lockbaum, this is an opportunity for you to put on your case if you wish to. You do not have to. But what I need to remind you is this is a writ of habeas corpus. And what I'm supposed to determine is there a valid governor's warrant signed off on by the governor of Tennessee and the governor of Texas that alleges that someone committed a felony offense in the state of Tennessee and that further identifies you as the person who is accused of committing that felony offense. And if all of those things are true, then you would have to be extradited to Tennessee to stand trial. And all of the arguments about whether they got the right guy, whether what was done, if anything, whether anything was done at all, and if something was done, whether that was criminal or not, that all has to be tried in Tennessee. So do you have any witnesses that you wish to call? Do you wish to be sworn in and testify yourself? What do you want to do?
My Honor, my wife and I went into Madison County Sheriff's Office.
All right, Mr. Lockbaum, if you wish to testify on your own behalf, then you must be sworn in.
Physical abuse.
All right, Mr. Lockbaum, if you wish to testify on your own behalf, then you must be sworn in. So do you wish to testify on your own behalf?
I'm challenging the jurisdiction of this court and the prosecutors.
All right.
Preliminary hearing.
Just make sure that we're being crystal clear, sir. I'm not telling you that you cannot testify as to anything that's relevant. I'm saying that just as Mr. Leday had to call witnesses and seek to have his pieces of evidence admitted into evidence, and he couldn't just stand up as an attorney and say, Judge, here's how it ought to be. You cannot do that. You may seek to have evidence admitted into with documents or anything else that is relevant admitted into evidence, and you may call witnesses and you may testify on your own behalf, but you may not, and I'll let you make argument in a moment, but I just want to make sure that you're perfectly clear that argument is not testimony.
My Honor, I would need time to prepare, to be able to review the information, just as Mark requested last week. I would need to prepare for that. And if you'd be
all right,
I would greatly appreciate it. And absolutely.
Okay. Is a week sufficient time?
A week is sufficient time, My Honor. Thank you.
All right. So we will return. The state has rested. We'll return at 2 p.m. on March the 9th. Okay. All right, so Mr. Lockbaum is excused. We're going to take a 20-minute break. I need to run a quick errand, and then we'll come back and knock out. I thought I saw Mr. Keendaws is back. We'll come back and work on his pleas.
Hey guys, luck bomb.
What time are we returning, sir?
3:50.
And Judge, just for clarification, I see that the 8th is a date for Wilson County. And then what?
Okay, let's get Mr. Lockbaum back. He's still in there then.
And I'm sorry, Judge, you have a trial week next week, so I assume you just want to hear it ad hoc on the 9th.
Yes, I was just giving him another week.
Yes,
No,
that's a good date
Okay.
Yeah, we'll be available.
All right.
for the civil side.
So no changes then. 2 p.m., March 9th. All right, we'll be in recess until 3:50. All right, I'm back. I'm here. And I asked Mr. Leday in the lock bomb case to make sure you get copies to the clerk or the Ms. Cavazos or whoever is going to be doing that.
I'll take care of that.
So Sellers, I think I downloaded all of that this morning. Let me go see if I can find it.
Do you need me to get him, Your Honor?
Yes, he's in custody, right? Let's get him knocked out.
Yes, sir. Let me grab him real quick.
Your Honor, I emailed you the Jose Rios judgment. If you will sign that and send it back to me.
Okay.
Here he is, Your Honor.
All right, thank you. And did you also send me the withholding orders, Ms. Sawyer?
I was not given withholding orders, Your Honor.
Oh, that's fine. I just didn't know if I didn't find them. I knew I had several this morning. I didn't know if it's because I did not download them or because they didn't come. Yeah, here they are, orders to withhold funds. All right, calling State versus James Everett Sellers. Are both sides ready?
It's ready, Judge.
Defense is ready, Your Honor.
Okay, are you James Everett Sellers?
Yes, Your Honor.
All right. All right. Mr. Give me a moment. All right, Mr. Sellers, can you speak, read, and write the English language?
Yes, sir.
And are you a United States citizen?
Yes, sir.
All right. Despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes, sir.
Do you have any history of mental health problems or mental illness?
No, sir.
Mr. Keendalls, do you believe your client is competent to stand trial?
Yes, Your Honor.
In cause number 2011-292, which I'm going to call the 20 case, you stand charged by indictment with the state jail felony offense of possession of a controlled substance. Specifically, it's alleged that here in Wilson County, on or about April 29th, 2018, that you did then and there knowingly or intentionally possess a controlled substance, methamphetamine, in an amount of less than 1 gram. That alleges a state jail felony, which is punishable by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, sir.
All right. Now, in cause number 194066, which I'm going to refer to as the 19 case, I understand that you're on felony community supervision or probation for the 3rd-degree felony offense of assault on a family member with a previous conviction. And is it true that you were found guilty of a 3rd-degree felony and placed on 10 years probation of a 10-year sentence on or about July 15th, 2019?
Yes, sir.
Okay. Now then, the state has filed a motion to have your probation revoked, and they're alleging that you violated rule number 17 of your probation. which is to say they're alleging that you failed to complete community service restitution hours at the rate of 16 hours a month in August through December of 2019 and in January of 2020. So do you understand what it is the state's alleging that you did wrong in the 19 case?
Yes, sir.
In both of these cases, do you understand that I am not bound by the plea bargain agreement that you have with the state? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
Yes, sir.
You understand also in both of these cases that if I do follow the plea bargain agreement that you've worked out with the state and the sentence I impose is not harder on you than what you have agreed to, you will not be able to appeal this matter.
Yes, sir.
All right. I'm going to show you some documents that appear to have your signature. We'll start in the 20 case. They're titled Admonitions to the Defendant for Plea to the Court. Let me ask on paragraph 2.11, is this your signature?
Yes, sir.
And also where it says verification.
Yes, sir.
And in the 19 case, the documents you were given were titled Written Waiver and Consent to Stipulation of Testimony, Motion to Revoke or Adjudicate. And let me ask on page 3, is this your signature?
Yes, sir.
And do you swear or affirm in both the 20 case and the 19 case that everything that appears above the signature I last asked you about is true and correct?
Yes, sir.
Okay. And in the 20 case, did you also sign at the trial court certification of appeal?
Yes, sir.
Agreed punishment recommendations?
Yes, sir.
Waiver of preservation of evidence?
Yes, sir.
And the discovery compliance certificate?
Yes, sir.
And in the 19 case, did you also sign on the plea bargain agreement
Yes, sir.
and the page 2 of the written waiver of time to file motion for new trial
Yes, sir.
and the trial court certification of appeal?
Yes, sir.
In both of these cases, did you read these documents yourself or did your attorney, Mr. Keendaws, read them to you?
Yes, sir.
Did you understand these documents before you signed them?
Yes, sir.
And are you satisfied with the work that Mr. Keendaws has done for you?
Yes, sir.
All right. Counsel, in both cases, do you believe that your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
Yes, Your Honor.
And do you also believe in the 20 case that you've received all of the discovery you're entitled to in a timely manner?
Yes, Your Honor.
Okay, I'll find that the defendant made his waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily in both cases, and that I will accept the discovery compliance certificate in the 20 case. All right, sir. So I'll ask you, in the 20 case to the allegation in the indictment of a state jail felony, possession of a controlled substance, do you plead guilty or not guilty?
No contest.
Okay, and you understand, sir, that a plea of no contest might be different than a plea of guilty if you got into a civil lawsuit about what you were doing on that date in 2018, but that for all purposes inside this criminal case, pleading no contest is the same as pleading guilty?
Yes, sir.
All right. Has anyone promised you anything to get you to enter your plea of no contest in the 20 case, other than your plea bargain with the state?
No, sir.
Has anyone promised you or anyone, has anyone harmed you or threatened you or anyone close to you to get you to enter this plea?
No, sir.
And has anyone promised you an early release from your sentence?
No, sir.
And that's on either case. Does that happen on either case?
No, sir.
All right. And in the 19 case, to the allegation that you violated Rule 19 of your probation by failing to complete your community service restitution hours as you were required to do, is that true or not true?
Pardon the interruption, Judge, it's Rule 17.
Rule 17, pardon me.
It's true.
I'll accept her plea of true, and I'll ask what evidence the state has to substantiate the defendant's guilt in the 20 case and the violation in the 19 case.
Your Honor, in both the 19 case and the 20 case, we offer states one and its attachments respectively.
No objection.
Without objection, State's Exhibit 1 and its attachments are admitted into evidence in both cases. Do both sides rest and close?
Rest and close, Judge.
Defense rests and close.
Okay. All right. I need a chance to look at the exhibits in the 20 case. All right, I'll find there is enough evidence to substantiate the defendant's guilt. And I'll also find that the state has substantiated the violation of his probation and that a change needs to be made in the disposition of that case. Are both sides ready for that hearing?
State's ready, Judge.
Defense is ready.
All right, is there a pre-sentence investigation or a waiver of a pre-sentence investigation?
Your Honor, the defense waives PSI.
Okay, what are the plea bargains in these cases?
Your Honor, in the 20 case, it's going to be 20 months incarceration in a state jail facility, court costs of $290 and restitution to DPS Crime Lab of $180. In the 19 case, Your Honor, it's going to be 3 years in a Texas Department of Criminal Justice facility and $249 in court costs.
That is the agreement, Your Honor.
Did you hear what was read in the record, Mr. Sellers?
Yes, sir.
And is that your agreement in these cases?
Yes, sir.
All right, anything else from either side?
Not from the state, Judge.
Not from the defense.
Okay, all right. I'll find out here I have enough evidence to make a decision in these cases without a pre-sentence investigation. In the 20 case, I'll find you guilty of the state jail felony offense of possession of a controlled substance and sentence you to 20 years, 20 months confinement plus court costs and restitution in conformity with your plea bargain with the state. And in the 19 case, I will revoke your probation and sentence you to 3 years confinement plus the unpaid portion of your court cost. Was there a fine in that?
No, Your Honor, just court costs and then restitution on the 19 case.
All right, plus the unpaid portion of your court cost. All right. Is there any legal reason why sentence should not now be imposed?
No, Your Honor.
All right, it's the order, judgment, decree of the court that you be taken by the sheriff of Wilson County and transported to the authorized receiving agent of the Department of Criminal Justice. Your sentences will commence today. They will run concurrently with any other sentences you may be under and with each other. And you'll also receive credit for all of the time you have spent so far in jail on these charges. And as the state and the defense come to an agreement on what that number is.
Your Honor, let me pull up the judgment. Your Honor, on the 20 case, 198 days and 196 days on the 19 case.
Does that sound correct?
Yes, Your Honor.
Right then. You understand, sir, that because I have followed the plea bargain agreements in these cases, that you have waived the right to appeal and you may not appeal?
Yes, sir.
James?
All right, then I'll find that you made your post-trial waivers knowingly, intelligently, and voluntarily. And I will certify to the Court of Appeals that you have waived the right to appeal as part of a plea bargain agreement and may not appeal. I wish you good luck, sir.
Thank you, Your Honor.
And do I have the judgments?
Yes, sir, you should have them. Now let me go in and look.
All right, yes, I have them. All right, let's see.
Okay.
You just parked, Mr. King Dollars, you're not on Amtrak? All right, I'm starting to send the documents to you, Ms. Sawyers. Okay, you should have received both withholding orders, both waiver packages, and both judgments.
Yes, sir, they're all here.
All right. So are both sides ready in State versus Sean Spalding?
Yes, Your Honor.
Are you Sean Spalding?
Yes, sir.
Is that your true and correct name?
Yes, sir.
All right. Mr. Spalding, can you speak, read, and write the English language?
Yes, sir.
Are you a United States citizen?
Yes, sir.
All right. Despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. So do you still wish to enter a plea today?
Yes, sir.
All right. Do you have any history of mental health problems or mental illness?
No, sir.
All right, counsel, do you believe your client is competent to stand trial?
Yes, Your Honor.
All right, sir, you stand charged by indictment with the third-degree felony offense of possession of a firearm by a felon. Specifically, it's alleged that in Wilson County, on about August 2nd, 2020, that you, having been convicted of the felony offense of possession of a controlled substance in June of 2017 in Guadalupe County, Texas, intentionally or knowingly possessed a firearm before the 5th anniversary of your release from confinement following conviction for that felony. That alleges a third-degree felony, which is punishable by confinement for not less than 2 and not more than 10 years, and by a fine that will exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, sir.
All right, and it's my
Sorry about that. My kids just got home.
that's fine. It's my understanding that this is an open plea and there is no plea bargain agreement.
That is
Yes,
correct.
sir.
All right. And is the defense going to be asking for probation?
Yes, Your Honor, on a PSI.
All right, and are you going to be asking for deferred adjudication?
Yes, Your Honor.
All right. All right, so you understand, sir, that what I'm being told is that you do not have an agreement with the state as to the disposition of this case, and that you are going to apparently plead either guilty or no contest, and that then there will be a research done by the probation office. They will prepare a document called a pre-sentence investigation report about you and about the circumstances of the offense, and that I will have an opportunity to consider that and to consider any other live witnesses or testimony that might be put on. And then I'll have a decision to make, and that decision could be confinement of not less than 2 and not more than 10 years, and a fine not to exceed $10,000. And furthermore, that could be probated, meaning that you might receive a sentence and then be placed on probation and not actually have to go and complete this sentence as long as you are doing what you're supposed to be doing on probation. And your attorney tells me that he's going to ask for deferred adjudication probation. If I was to grant you deferred adjudication probation, I would find there was enough evidence to say you were guilty, but I would not do so. Instead, I would place you on deferred adjudication probation. And if you successfully completed that type of probation, the case against you would be dismissed. You would have no conviction, and you might be able to get an order of non-disclosure to keep the state from telling anyone other than law enforcement that you were even arrested in this case. On the other hand, if while you're on deferred adjudication probation, the state was to allege that you were violating the rules, you could be arrested and brought back to court, and there would be a hearing on just that question. Did you break the rules? And if the answer to that turns out to be yes, then you could be found guilty, and you could be sentenced to anything that's a legal sentence for a third-degree felony, confinement for not less than 2 and not more than 10 years, and by a fine not to exceed $10,000. Do you understand that?
Yes, sir.
Right. I want to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Open Plea to the Court. And let me go down here to paragraph 2.11. Is this your signature? Are you able to? Oh, it
didn't share.
Okay.
There we go.
Sharing now. Okay.
There we go. Yes, sir. That is my signature.
All right. And the next page where it says verification, is that your signature?
Yes, sir.
And do you swear or affirm to me and to the clerk's office that everything that appears above your signature is true and correct?
Yes, I do.
All right. And did you also sign? Well, I was going to say on the trial court certification of right of appeal, but is that your signature, sir?
Yes, sir. Down there on the bottom. With the way everything got printed out and chopped up at the UPS store, which I, by the way, will not be using them again.
Okay.
I didn't realize it was that chopped up until I started going through it with my attorney yesterday.
Okay. All right, that's fine. You and he both have the same first name, so I was concerned there for a moment.
Yes, sir.
All right. And on the next page where it says agreed punishment recommendations, is that your signature?
Yes, sir.
And on the waiver of preservation of evidence?
Yes, sir.
And on the discovery compliance certificate?
Yes, sir.
And just to make sure we're all on the same page, the page that went through the fax machine and everything with the signature blank for Mr. Leday and myself did not make it. So we re-added that page here.
Yes, sir.
All right. So did you read these documents yourself before you signed them, or did Mr. Keendaws read them to you?
He read through them with me. Yes, sir.
Did you understand these documents before you signed them?
Yes, sir, I did.
And are you satisfied with the work that Mr. Keendaws has done for you in this case? So far?
Absolutely. Absolutely.
All right. Counsel, do you believe that you've received all the discovery you're entitled to in a timely manner?
Yes, Your Honor.
Okay. And do you also believe that your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain with the state?
Yes, Your Honor.
All right, sir. I will accept the discovery compliance certificate, and I will also find that you made your waivers and your stipulations of evidence knowingly, voluntarily, and I will approve them. And I will ask you to the allegation in the indictment, third-degree felony possession of a firearm by a felon, you plead guilty or not guilty?
Guilty.
All right. Has anyone promised you anything other than your plea bargain agreement to get you to plead guilty?
No, sir.
All right, I'm going to ask you to try and get the noise down in the background so the court reporter can take this all down.
Yes, sir. Let me see if I can step outside. Is that better?
Okay. All right. Has anyone promised you an early release from your sentence?
No, sir.
And I may have already asked this, but has anyone harmed or anyone close to you to get you to make this plea?
No, sir.
Okay, I'll find that you made your plea voluntarily and you're not in any compulsion of making it, and I will accept it. And I'll ask what evidence the state has to substantiate the offense.
We offer states one and its attachments.
No objection, Your Honor.
All right, without objection, State's Exhibit 1 and its attachments are admitted into evidence. Do both sides rest and close at this stage?
Let's close.
Defense rests and close.
The attachments. All right, and has Mr. Spalding been charged in Bear County or Wilson County or anywhere for anything to do with the trailer?
No, sir. I'm still waiting a court date. I haven't even been provided an attorney in that case. I was in court last month on it, and I believe I have a reset date of the 14th of this month. Not real sure on that. I have to go back and check on it. In that case, I will be entering a not guilty plea. I have sufficient evidence to support my case in that matter. The trailer was borrowed.
And
Yeah.
Let's not get into all that.
Yes, sir.
I'm just hesitant to go forward in this on sentencing until we know what's going to happen in the Bear County case, or have some idea what's going to happen in the Bear.
I believe that was out of, I'm going to court on that in Wilson County.
Right, yes. It was charged as a misdemeanor, right? Sean, is that correct?
Yes, sir, I believe so. It's theft of property.
Okay. All right, so that was charged as a misdemeanor in Bear County, in Wilson County.
Yes, sir.
Okay. All right, well, I'll find there's enough evidence to find that the defendant is guilty of the offense. And how long does probation need to, and let's get this on the record if we didn't already, I think we know we did, that this is open, please. So how long does probation need to get ready?
Your Honor, at least a month. I know we have the 29th. If Mr. Spalding, I don't know if he's available to come in the office tomorrow. If we can do an interview that quickly, we can have it done for the 29th. If not, I don't think you're back till mid-April.
All right, well, I mean, we don't have to put it off that long. We can if need be, but.
We can do the 29th.
Okay, so will that work for everyone else?
Yes, Your Honor.
That's fine with us, Judge.
All right, then I'll order a precedence investigation to be prepared and set this for further proceedings on March the 29th or April? March 29th?
Yes.
March, yes.
All right, Mr. Spalding, I'll let you know that it seems about half the time recently, whenever I do this, the report that the probation office sends back says that we called the defendant a bunch of times and we emailed them and they never would get back with us. And I have to tell you that when that happens and the defendant never gets back with the probation office who's working on that precedence investigation report, that puts their defense attorney in a very difficult position whenever they have to come in and try and argue that I could believe that the defendant's going to show up and go to probation when they're on probation, when the defendant wouldn't even show up and meet with probation when they were looking at the possibility of going to prison. So make sure that you work with the probation office, get with them and get the precedence.
What time tomorrow do I need to be there?
That's going to be all between
Yes,
you
sir.
and the probation office. I just want to make sure that you do that.
Yes, sir.
All right, then. So I will ask Mr. Keendaws to send me that reset or that setting in the chat. And after that, you and he are excused.
Jennifer, can you, me and Mr. Spalding, don't leave yet, Mr. Spalding. Can you put
Yes,
us
sir.
in the breakout room?
Yes, sir.
Okay, is there anything else we need to do except go over the docket?
I still just need the Jose Rios
I'm
judgment that
sorry.
I emailed to you.
All right, and oh, wait, let me. Ms. Sawyers, if you would, because this is so messed up, sign the verification. I'd appreciate it, and I'm going to sign everything that needs to be signed prior to
The sentencing.
this being finalized.
Okay.
Okay, Your Honor, I posted the date in chat. May I be excused?
Yes, sir, if that's all you have.
Yes. All right, thank you, Your Honor.
All right, so let me post this to Ms. Sawyers. Rios judgment. Okay, I just posted the Rios judgment.
Mr. Spalding, your attorney posted everything in chat, so I believe you are done.
All right, let me see if I have any questions on my docket. Do we ever get a date on Gerardo Gonzalez?
I have 3-5 on my docket. It's page 3, this first one, Cindy.
Okay, that's Friday?
5-3?
Possibly, but that's a monitor commitment. Do we have that much time?
Judge, let's just put it down.
That's 40
If we have a deadline by then, we'll take care of it and get it to you.
Okay. And SAP is still a nice eye. Gibson's still a nice eye.
I saw that Richard Briggs had posted a date for Gibson. Was that an error?
Let's ask him.
It should be, because we talked about the fact that Mr. Gibson wasn't in DeWitt County.
Okay, and I guess Mr. Briggs was gone when y'all mentioned.
Well, Mr. Briggs said that he called back and he was there. Remember that was him and Lorena saying where Lorena got one answer and he got another?
Oh, yeah.
So that's why he posted the 3-8 date.
Yes.
All right, I'll put 3-8 in. I mean, you can, on the nice side, we won't sign anything. Just he's on, maybe his client's on double secret probation there in Cuero. All right, I think that's everybody. Is that everybody? Sellers, final judgment, Houghton, Spalding. Okay, what day do we get Spalding? 28?
29.
29. Okay. All right, anything else we need to work on?
Not much.
All right. Well, I took my computer to get worked on Friday, and it didn't seem to have done much good. I thought it was working better Friday afternoon, but now it's doing something where it won't let me put my signature on. I put it down and it disappears. And I have to print it to a PDF, but only on certain parts of the document. So I don't.
Nobody can accuse you of not trying. I think you've got the good fight with that laptop for a new one.
Yeah, well.
I say we chunk it and get you a brand new one.
Yeah.
Let's see if that's in the budget. Let's see if that's Brad putting codes in there. Make that happen. Okay, I will.
I'll write them at the window.
See y'all tomorrow, I guess. And I posted Spalding, yes. Okay. And Mr. Keendawes is gone? Okay. All right. It does. I'm just thinking out loud. They had the case from Missouri last year where apparently part of the state's burden in Missouri is to show that the firearm was functional, but that's not it here. I mean, I assume that you could like run over a firearm and melt it down into a cube, and after a while you'd have something that you couldn't charge somebody with a firearm with. But I'm not aware of there being any defense that or exception that if it doesn't work, it's not a firearm as long as it looks like one. Is that the state's thought?
Well, and Judge, to be honest, is no evidence before the court whether it was operable or not.
Operating or not, yeah, that's true. But Okay, I was just thinking out loud. But like I said, as long as it still looks like a firearm, just like it didn't matter if it's not loaded.
Right.
All right, I will see y'all in the morning.
Take care, Jeff.